you have to just do it digitally. You have to pay the stamp duty again digitally. Then you have to log in to the registration. And even at the registration office, if you're attending, you need not even to affix your photograph on the papers. You have to simply sit across the registrar, sitting with his computer and the camera. He clicks your photo then and there. Then he takes your fingerprints on digital mode, and lo and behold, your document is registered digitally. Now, once the documents are digitally registered, the courts in the case of litigation were flooded by these digital documents. Now, prior to the introduction of the Information Technology Act, and as we were aware that prior to 2023, we were governed by the Indian Evidence Act 1872. It is in the year 2023 that Indian Evidence Act was replaced by Bharatiya Sakshya Adhiniyam 2023. Therefore, after 2000, there were amendments in the Indian Evidence Act, a lot of amendments which were including these digital platforms and digital kind of evidences. But then 2023 altogether changed that Bharatiya Sakshya Adhiniyam and start incorporated all these things. Now, gradually, this new phenomena called artificial intelligence came along because the world is developing in a fast pace. Now, as far as law is concerned, exclusively on artificial intelligence, the Parliament of India has yet to come up with a statute dedicated to artificial intelligence. Though the Home Ministry has been trying to kind of do some sporadic actions to control the misuse of artificial intelligence. There are some very landmark judgments of the Supreme Court also on these misuse of artificial intelligence, because you must all have heard of a term called deep fake. Now, deep fake is again a misuse of artificial intelligence. Now, what happens is that whenever a good thing is introduced or brought in for the assistance of the world, there are a lot of advantages of artificial intelligence, but some of the perverted minds, they always misuse the best things available in the world. Now, if we talk about the artificial intelligence vis-a-vis law, then the current lot of students of law, with the use of artificial intelligence, have been performing very quick and fast. What took us or our generation ages to develop the skill of drafting a contract or drafting a petition, finding appropriate words, appropriate sentences, framing that, and seeing, cutting again and again, and then redrafting it to bring to the best of interest of the client. Nowadays, all this hard work which we underwent is done in a jiffy, because there are ready-made platforms. You have to simply put in your problem and ask the artificial intelligence to produce a draft, a ready-made draft on that subject or your problem is immediately brought in. Then you have to do your little bit of editing and your draft is ready, and much better worded than you could have at the junior stage. So this is the advantage of the artificial intelligence. Secondly, when we were training as lawyers, at that time there were no computers as well. So we used to sit in the library to research on the law, as our seniors used to give us the problem, and we have to find out the citations and the judgments of the Supreme Court or various high courts across India to assist on the point of law or on the point of the dispute. And it used to take hours sitting in the library to find one citation of some use. Sometimes we used to work for days because most of the citations we found out and produced before the senior, he used to reject it, that no, it's not up to the mark. Go back and research further. Now, at the moment, I'm also assisted by a set of researchers. They produce, to my astonishment, they bring the appropriate citation within minutes. This is the benefit of AI, because the moment you put in your problem or dispute, AI stifles through the data, and wherever he gets the AI gets the matching connecting citation, it produces instantly. So these are the advantages of AI which has come to the fore as far as the legal profession is concerned. Nowadays, even Supreme Court and most of the high courts have gone digital. Nowadays, e-filing is compulsory in all courts. Then the video conferencing has begun a name of the game. We argue matters across India sitting in our office, whereas few years back we used to fly across India. The very evidence of this digital development is the one which we are undergoing at the very moment. This conference I'm addressing digitally through video conferencing, which was unheard of few years back. Although it's my loss as well that I did not get an opportunity to visit your august institution and to enjoy the wonderful hosting of Dr. Madhura with a cup of coffee and sandwiches. This is the loss by the AI and by the digital platforms. If Dr. Madhura is listening to me, I put my claim to a cup of coffee and sandwich whenever we meet again.
Sure, sir, sure.
Moving ahead, there are other disadvantages as well as of the AI. The disadvantages which we're talking about, one of them is that deep fake. People take misuse, and you must have seen the fake videos of Honorable Prime Minister of India, various ministers of India, various actors, actresses, I mean, whatnot. People get confused to find what is real and what is fake. There are some judgments on that deep fake where the government of India has directed the intermediaries or the platforms to remove such videos not being authentic. There is an effort going on to create certain more digitally enriched platforms to make a distinction between the real and the deep fake. But that's again, it's a tussle, it's a battle which goes on. If you remember, the first very landmark judgment of the Supreme Court of India in the year 2015, that was of Shreya Singhal versus Union of India. Now, Shreya Singhal was just an 18-year-old girl, and one day she received a Facebook message from her friend, who was again some 18, 20 years old girl. They were friends and they were exchanging messages on Facebook. So her friend sent a Facebook message to Shreya in respect of the sad demise of Balasaheb Thackeray. Now, Due to the sad demise of Balasaheb Thackeray, there was a lot of public outcry, and people were on street and they were sad and they were grieving, and there was a lot of traffic jams on the roads of Mumbai. Now, without understanding the gravity and the greatness of the great leader, departed leader, this friend of Shreya sent a message to Shreya that what traffic nuisance is going on, and the police must do something about this. There should not be any chaos. Whoever dies or wins or celebrates, the road jams should not be allowed, and the chaos in the society should not be allowed. She made this innocuous message to her friend on Facebook. Her friend, who's again an 18-year-old girl, liked that comment. That's it. This was the crime. And lo and behold, both the girls were arrested under Section 66A of the Information Technology Act of 2000. This arrest of two girls shook the nation. There was a lot of huge and cry across India that these are heinous provisions, draconian provisions, and how can you arrest two innocent girls who are exchanging messages on a Facebook among themselves, between them? But Facebook, etc., being a public platform, it was considered a crime of disseminating hatred and creating chaos in the society. This incident happened in somewhere November 2012. The matter went up to the Honorable Supreme Court, and this decision of Shreya Singhal versus Union of India came in the year 2015, where the Supreme Court, alarmed by this incident and the draconian provision, struck down Section 66A of the Information Technology Act. Those who are law students, I recommend, must go through this judgment of the Supreme Court, which will give you a lot of insight about this digital platforms. And in all my speeches across India, wherever I'm invited, I warn people to be very careful when you're using these public platforms, digital platforms, social media platforms like Facebook, Instagram, LinkedIn, WhatsApp, and a lot of platforms which are circulating. At that time, it was only Facebook. Now there are so many: Telegram, Instagram, and whatnot. One should be very careful because Shreya's sin or the crime was only liking the post. That's it. So be very careful when you like the post also, or if you find that there is something offensive which may hurt the public at large, ignore it. Forget about responding or creating such data or posts. You should be very careful even before you like it, because liking was also, see what havoc had happened. If you read that judgment, what is important to notice is that though Section 66A was struck down by the Honorable Supreme Court, in that guise, the Supreme Court strengthened Section 69A as well as Section 79 of the Information Technology Act, which had given an exemption to the intermediaries, like these platforms, because IT Act till 2000 had given exemptions to these platforms that if the post is offensive, the author of the post, the receiver of the post, and those who are liking the post would be charged with the offense, but not the platform on which it is done. Like nowadays, a lot of offensive material you can find on Twitter, which has now become X, Instagram, WhatsApp, Facebook, LinkedIn. So the platforms are giving exemption under Section 79. Though recently there has been an amendment in the Information Technology Act in the year 2021, and very lately in February 2026, the information technology rules are made. There are changes made because by the Amendment Act of 2021, there were provisions and the power given to the government of India to immediately notify the platforms to deload the offensive contents and block that site within 36 hours of receiving the notice. Because all these platforms, if operating in India, have to get themselves registered in India under Indian laws as well. And therefore, the government gets a control over them. Though still there is no censor board to take care of the material on social media, and there is no regulation on artificial intelligence at the moment. Things are going on. Very soon you will find, though there is a DPDP Act of 2023 has already been introduced, that is Digital Personal Data Act. Now, therefore, by the rules February 2026, that 36 hours window to deload the material has been brought down to 3 hours. That as soon as the government finds that there is some distorted material on social platform, the government can immediately direct the social platform like Twitter, Facebook, etc. to deload that material, block that site for public consumption within 3 hours. And I'm told that the government is not happy even with the 3 hours, and it has been now shrinking to 1 hour. That as soon as it is uploaded, the platforms are notified and they immediately have to put it down within an hour. Because gone are the days when everything moved in a snail pace. This is a digital world. You have to be very fast to take action. Otherwise, before you deload the material, it is uploaded and public has consumed it. You might have seen that some people who post something offensive, and the moment they load it and the kind of outcry comes and they have to delete it immediately, but by then, by before they delete it, people have already noted it. You recently must have heard in the newspapers or the news that some draft had been sent to the Prime Minister of Pakistan to be uploaded on his X handle. And unfortunately, the Prime Minister of Pakistan, without bothering to edit that title, the draft to be put on platform by Prime Minister of Pakistan, which was the heading, and then there was a message. He uploaded in a haste the entire message on the platform. And it became a mockery across the world that the Prime Minister of Pakistan has not even bothered to delete the title. The moment this outcry happened, he uploaded, and the moment the outcry happened, immediately deleted it and then edited and uploaded. But by then, the world knew. So the damage happens so fast, it's all so quick that the government is shrinking that window from 36 hours to 3 hours, and now the work is going on for an hour. And who knows, that 1 hour will also be a longer period in future and maybe shrinking much more down. Another landmark judgment which I want to bring before the audience is that Puttuswamy's judgment, 2017 Supreme Court, where for the first time right of privacy has been brought in as a right, as a fundamental right by the Supreme Court of India. Because if you see the fundamental rights from Article 12 to 35 in the Constitution of India, right of privacy as such is not worded in the fundamental rights. But the Supreme Court of India, interpreting Article 21, has stretched it that everybody has a right of privacy and his privacy cannot be breached. And on the basis of this Puttuswamy's judgment, it is now considered that Article 21 is a fundamental right and it includes right of privacy. That's where this deep fake is taken care of, and the breach of privacy is the justification that the fundamental right is being breached, that the Supreme Court and the High Courts give directions to these platforms to immediately remove that offensive data. So that's how law is also catching up. Things are moving fast, and there are so many things which have to be discussed, and there is so much of material. I'm sure the coming speakers, which I have been notified by your institution, that there are a lot of speakers and a lot of data, a lot of material will be exchanged, and it's an international conference. So I'm sure that people from across the world will enrich your knowledge, kitty knowledge, and the students of law and the faculty and management of Hindi Vidya Prachar Samiti are to be hailed, and I thank them to give me a great opportunity to address you all on this wonderful topic. And I hope that somewhere in the future, if once again we get an opportunity, I'll bring a lot of more material and data as far as artificial intelligence is concerned, because this area is developing very fast on a fast pace. Every day things are happening, and positive aspect is that courts are also taking use of AI. Courts are also digitally enriched now. We lawyers are working hard. Your institutions libraries, which were earlier full of books, now are full of computers as well. Law softwares are available to law students. So I wish all the law students to kind of update all of yourselves and knowledge and be with the pace of the world. Our generation has to take a longer time to get accustomed to this development and artificial intelligence. The younger generation is born with this. They are much faster, much better. And the interns which work in our office are of great help to me as well. And I'm so happy that Hindi Vidya Prachar Samiti has brought such a wonderful topic, an apt topic for the enrichment of its institutions, students, faculty, and the world at large. I thank you all once again to have given me this opportunity. I thank Hindi Vidya Prachar Samiti, Dr. Madhura, your chairman, and your Professor Saisha, and other faculties, and I wish and look forward to join you all again soon, but this time offline with a sandwich and a cup of coffee. Jai Hind. Thank you.
Thank you, sir. It was a privilege to listen to your valuable insights and experience. Your words have truly enlightened us with a deeper understanding. Thank you, sir, for sharing your knowledge and inspiring us.
Thank you, sir.
Moving on.
Am I allowed to leave the meeting because I have to rush to court?
Yes, sir. Yes, sir.
Thank you.
Moving ahead, it is my privilege to introduce Miss Kriti Srivastav ma'am, an emerging and dynamic academic in the field of law. She is currently serving as an assistant professor at the law at your National Law University, Odisha. With over 4 years of teaching experience, her areas of interest include constitutional law, administrative law, public policy, and intersections of artificial intelligence and law. She is presently pursuing her PhD at IIT Bombay, where her research focuses on technology and access to justice, particularly the role of AI and online dispute resolution in her legal system. I now invite Ms. Kriti Srivastav, ma'am, to kindly address the gathering.
Good morning, everyone. It is a pleasure to be a part of the International Conference on Artificial Intelligence and Law. I thank the institution Hindi Vidya Prachar Samiti for inviting me as the resource person. Today, I'll be talking about the emerging technology, which is the deep fakes, which are becoming popular in the domain of artificial intelligence. The esteemed previous speaker also touched upon the topic of deep fakes. I request the team to kindly upload the PPT, share the PPT with everyone. So today I want to speak about the deepfake and the impact it has on the society. Now, this is a very complicated yet a very concerning domain which has impacted our lives in an unimaginable way. So I'll begin my discussion with the simple question, which is that whenever we see something, we tend to believe it. This is something which has been the law of the nature as well as the primary assumption we as human beings have. But what happens when we see something but are not able to believe? So this is something which has become the concern with respect to this emerging technology of deepfake. Now, for a very long time, we have seen the audiovisual evidences such as photographs or recordings, videos, something which could be said to be the most reliable form of truth. But that assumption has started collapsing. And now we are entering into an era, as the previous speaker was also mentioning, where artificial intelligence is something which generates things not which are not even existing, which might not have ever existed. So these are not just crude manipulations, they are something which is so persuasive in nature, so scalable, and it is becoming increasingly accessible. And deep fakes should not only be seen as a technological novelty, but something which is actually posing a transformative socio-legal challenge, reshaping the trust which we put in the things we see, in the things we observe, the kind of harm it is posing to the individuals. It is also having a negative impact on the democracy. And needless to say, because we have a very limited version of legal framework with respect to technology, with respect to artificial intelligence. So the emergence of such novel forms of usages of AI has posed a very harsh reality in front of us, that whatever legal frameworks we have, it is very limited in nature. So this is something which is what I'll be talking about in this conversation with the audience. How deepfake is emerging, how it is impacting the society, what is the truth behind it, what would be the future of evidence if we keep on inculcating the deepfake technology in our day-to-day lives. Now, what are deepfakes? So at the technical level, if we have to define what is a deepfake, it is a synthetic media which is generated using the artificial intelligence. Particularly, the models which are used behind it are generative adversarial networks. Now, these videos or the images or the kind of files which is used to create by deepfake is so realistic in nature that it has a very high fidelity rate. For example, let's say something which is not real, but a very realistic version of the kind of representation which we see of individuals' faces, voices, actions, etc. The previous speaker was also talking about a very famous video which was being circulated of our Honorable Prime Minister Narendra Modi, where the kind of manipulation which is done, it would show that a political leader is giving a speech which they have never delivered. So this is concerning because it is a direct attack on the democracy in the country. Similarly, these videos, these technologies actually fabricate conversations. So cloning a person's voice to fabricate conversations, inserting someone's face into entirely different contexts, these are something which are the potential misuses of this deepfake technology. Now, we have already been aware of this idea of Photoshop. It has been in the realm for quite a long time, and I think at one point in time, each of us might have even used it. It is used to create filters, it is used to maybe perfect the kind of image we want to show to the world. So, what is something which is distinguishing deepfake from earlier tools like Photoshop? Firstly, deepfakes are so real that people are unable to distinguish it from the authentic media. They are mass produced, they have high rates of accessibility. So I do not need to be an expert in creating a video or an image using deepfake technology. So this is something which is crucial for us to understand, that now the power to fabricate reality is something which is no longer limited to the government or to sophisticated studios. It is now a democratized reception which can be done at a finger's click by anyone somebody who does not even have the kind of knowledge which is required can do it with the help of deepfake videos, deepfake technology. And that is something which is now the concern of what impact it is having on society. Because if we see the social implications, there is a huge collapse of trust. And this is like the most immediate consequence of deepfake technology. Now, traditionally, we see that whenever such audio-visual proof are made or are made available, people blindly tend to rely on it. For example, if I show you a video and say that this is a video which is being circulated on the internet showcasing the reality of Indian media, all of us would very likely to start believe it. So this is something which is a kind of a problem where people are relying on video or audio references. Even our journalists, they depend on recorded proof. So what we do is the public discourse actually treats the visual evidence as authoritative. We are not going to question it. We are not going to go and do fact check whether it is actually correct or not. The first impression which we will have over for that video or for that image would be that this is the correct information. This is the truth which is being presented to us. Now, the problem here is that even if we have something which is correct, which is true, the information is reliable, still the impact of it would be that because we have been so much exposed to the kind of false fabricated videos, that it might create a narrative in our heads that this video, even if the information is correct, might be created by using artificial intelligence. So deepfakes are actually destabilizing the foundation where we are unable to distinguish between what is reality and what is fabrication. And there is a term which is now being used by different scholars to explain this entire systematic uncertainty, and the term is the liar's dividend. So liar's dividend is that even if you are presenting a genuine evidence, it could be dismissed as fake, because this existence of the technology, the existence of deepfake technology is creating plausible deniability. It means that it is very much possible to deny something just to refer to it as something which is created using artificial intelligence, and thus it could be dismissed as fake. So this is something which is undermining the accountability which we would want a person or an institution to be holding. Similarly, another aspect of it is, for example, let's say if I say that there is a video which is being circulated, maybe highlighting the kind of misconduct people do often in public offices. So it would be very easy to take it as a defense that this video is not real. So because this is deepfake, so there is an uncertainty that how are you actually going to prove that such a misconduct has happened. So this is something which is seen as a mode of weakening the accountability mechanisms which exist for now. Another aspect of it is the kind of social harms it possesses. So one of the most disturbing cases of deepfake technology is the use of such technology in causing reputational damage to people. For example, we talk about the kind of sexually explicit videos which are made using deepfake technology. So it would fall in the category of non-consensual pornographic content. So this would be something which would be used to disproportionately target women. It could cause reputational damage, again leading to psychological harm, trauma, and harassment. So this harm would exist even if we know, even if as users or as consumers, we know that the content is fake. Now, this is something which is actually revealing something very profound, that when we talk about deepfake harm, it is not just about deception. So if I create a video showing that a certain person is involved in doing something which is considered to be inappropriate by the moral standards of society, even if the video is fake, even if it is seen as a deception, still it is creating a harm where there has been an identity violation and violation of dignity. So this is something which is actually seen as a way of imbalancing the power in the society and giving rise to challenges of identity misuse. Moving forward, now, there is another important aspect of this entire technology of deepfake and its impact on the society. Now, in India, we all know that we have a very good governance system with respect to the kind of democratic values which we have provided by the Constitution of India. But when we talk about the technology of deepfake, it is also seen as a direct threat to the democratic processes. For example, if the deepfake videos are strategically used, it can be used to dismantle the core pillars of democracy. Some examples which I would like to point out here is that often we see that on social media there are fabricated videos of politicians doing something, or something where false statements are included in a video which is attributed to certain candidates. So this is the use of synthetic media, which is creating the kind of unrest in the society, maybe right before elections or during elections, just to shift the narrative that the particular political party or the particular politician is not a suitable candidate for running the elections. So this is something which is considered to be a strategic use of deepfake video. Another is the kind of emotional realism deepfake videos create. For example, if you are creating a video and you want to convince a certain section of the audience, you will intend to make it more persuasive. And why would you do so? Because something which is more persuasive, because what we see, we believe. So if we are seeing something and it is believable enough, it is very hard to debunk that misinformation. So any misinformation travels faster more than the concrete information. So if something is very persuasive in nature, it is going to be difficult to debunk it. It will be very easily spread across the society. And this is something which is seen as an epistemic instability, a condition where the citizen will no longer agree to what is true and what is not true. So if you have not prepared to create a system where it is easy to debunk such videos, or to flag out that such videos are just being created to create misinformation in the society, it is actually going to weaken the democratic deliberation. Similarly, when democracy weakens, we all know that polarization is something which would increase. There would be a low institutional trust which we would place in the institution. So when we talk about the impact of deepfakes, it is not only about misinformation, but it is something more than that, something which is going to fracture the informational foundation of democracy. Now, it could be seen as something which is like, as I stated earlier, the example of epistemic instability. So the threat to democratic deliberation would arise when we as citizens would become unsure of what we need to trust, what we need not to trust, how the factual reality is portrayed to us, how are we able to break down the shared factual reality. All these things become interconnected, and that is how it is a concerning area with respect to the creation of deepfake videos, deepfake images, deepfake audios, and its impact on democracy. From a legal standpoint, deepfakes are again deeply disruptive because, as stated earlier, there are limitations of our legal framework, and these deepfake technology videos do not fit neatly into the existing categories we have. If we talk about the implication of deepfake, how do we actually hold somebody accountable for creating nuisance in the society with the help of deepfake videos? We can say, with respect to the existing laws, there are certain things which we can point out that how deepfake is actually harming the person. For example, we all know what defamation is. Defamation is when you are tarnishing somebody's reputation, and that person has been known to have a certain kind of image in the society. And if people start believing the false facts about that person, it simply means that the reputation is being tarnished. So, false statements which are harming reputation falls under defamation. So, if I create a deepfake video, a technology which is actually propagating false information about something, then ultimately it would attract the provisions of defamation. Similarly, it has been seen that it is also responsible for privacy violations, committing fraud, and it also attracts the obscenity laws. But why the existing laws which we have to tackle these problems fail in case of deepfake? Because when we talk about defamation, even if, let's say, the viewer knows that it is false, how are you going to erase the kind of perspective viewers have developed with respect to the false information. I know that the person who is addressing the society in the video, or let's say a person engaged in something morally unacceptable in the society in the video, all of it is fake. All of it has been used as just a means to defame that person. But the kind of perspective I have developed in my mind with respect to, okay, what if this information is actually true? It is easy to say that, this is something which has been created using AI, but what if in reality it is not? So defamation law requires that I believe in the falsity of the information. But even if I know that, there is a probable chance that this is something which is the result or a consequence of this deepfake technology, but what if I am not convinced 100% that this information is fake? So current defamation law falls short of including deepfake technology in it. Similarly, when we talk about privacy law, so right to privacy is now seen as an integral part of Article 21. The previous esteemed speaker also spoke about the Justice K.S. Puttaswamy judgment. Now, Justice K.S. Puttaswamy judgment has very clearly laid down foundational principles of privacy. Privacy includes bodily autonomy, decisional autonomy, informational autonomy. And it is an individual's right to protect it under Article 21, which is right to life and personal liberty. Now, the current privacy regime fails to include deepfake technology because deepfakes are not private facts. It is a manipulated version of a person's personality, and it is being shown as something which is in relation to that person. So it will become very difficult to actually prove that privacy is something which is being violated. Similarly, when we talk about privacy rights, it automatically leads us to the idea of emotional distress claims. So emotional distress claims, if I'm emotionally affected, if my privacy is being violated, if because of the video it has impacted my day-to-day life, it is very hard to actually claim under the current legal framework that my emotional distress would also mean something which would help me in getting my fundamental right exercised. So this is something which is the problem with respect to the current legal framework. So what we can safely conclude here is that deepfakes is sitting at the intersection of truth and falsity. The identity is real, but the conduct is fake. So if the conduct is fake, it is showing that the person's identity is being used. So this is something which is a kind of doctrinal gap in the existing literature with respect to deepfake and the emerging idea of the justice system, the legal system. Moving forward, another important aspect of the deepfake technology is the impact it is actually having on the value of evidences. So we, as mentioned earlier, when we see an audiovisual evidence, we assume it to be true because earlier the technology was not advanced that people would be able to create false evidences with the help of it. But now the challenges with respect to evidence is that it is difficult to prove that the evidence is authentic. Standards of proof might change with the introduction of deepfake technology. We cannot rely on the recordings anymore because again, confession can be fabricated using voice cloning. Fake video can be used to establish alibi or guilt. Now the most fundamental reality in front of the courts is that audiovisual evidence is no longer presumptively reliable. So what we would need to do is that we would need to maybe have an advanced version of forensic verification. We might have to rely upon expert testimony a lot more than now what we do now. We definitely need a very sharp introduction of judicial literacy with respect to AI technologies, because the current judicial setup, although Indian courts, the Supreme Court of India has come up with the e-courts mission mode project. They are very much interested in engaging AI tools. We have several AI tools running in the Supreme Court, but the kind of work which requires a very precise understanding of artificial intelligence with respect to calibrating the evidentiary standards is something which is now being forced by deepfake technology. So this is something which is a about the impact of deepfake on the justice system. Now, there is a very crucial distinction which I wanted to discuss here today. When we talk about the impact of deepfake, there are two types of deepfake, which is now seen as the popular categories in order to come up with the kind of offenses which we would put in these two categories. So first, deepfake is the pornographic deepfakes, which is very harmful, which is the example of how dignity and sexual autonomy is being violated. It is obviously non-consensual. It is seen as extremely wrongful, and it requires criminalization. It persists even if it is labeled fake. So something which is there, even if everybody knows that it is fake, it is totally it destroys the morale of the society, as something which you're not able to remove from the knowledge of the people. Even if people know it to be false, it is going to violate the dignity of the person involved in very extremely wrongful manners. The second kind is the attitudinal deepfakes, which are also called non-pornographic. So this is something where we see falsity of political, social, or behavioral representations. Now, this is something where public perception changes a lot. So it is more context dependent. It is obviously less harmful than the other category, but it needs a clear label. It will become more harmful as the kind of defamatory material it involves increases. So this distinction is clear, and it requires the clarity, because it help us in understanding that what could be our different legal responses to the different kinds of harms which are posed by deepfakes. Another thing is that when we talk about the core legal argument, which is being expressed with the help of scholars, the literature available, and this is something which is now being seen as something where we would need a proper dual framework of saying that how identity appropriation and lack of consent is something which is the real harm with respect to deepfake videos. So harm is not something which would totally be dependent on the idea of belief. If there is a dignitary harm, even if people believe it to be fake, the harm would still persist. Coming to the Indian context, we have a very famous case with respect to this deepfake technology. The name of the case is Codable Arijit Singh versus Codable Ventures LLP. So this is actually a very significant development with respect to deepfake technology and the idea of personality rights. Now, this is actually a turning point in how courts have started addressing AI-driven deepfakes. So the facts of the case are pretty simple. Arijit Singh, we all know, is a very famous playback singer in Bollywood. So there was a incident where his voice was used as a mode of helping to clone more similar voices. So his voice was used as a model for voice cloning, and as a result of that, several deepfake music performance videos were created. And there was a commercial exploitation, obviously, because it was without consent. So here, the legal claims of the petitioner, of the singer, was that it is violating his personality and publicity rights, leading to reputational harm. We have a concept of moral rights in the copyright law. So it is again a violation of moral rights. So here, the court was of the opinion that when we create something which is generated by AI, and if it is imitating somebody or someone's personality, it is equivalent to human impersonation. And this is something which is doctrinally very significant, because it recognizes voice as a protected identity. It treats algorithm replication as an actionable harm. And again, personality rights, something which is now being extended to AI domain. So here, an injunction was passed. It was directed that all the videos, all the voice recordings which are replicating the singer's voice should be taken down. And it also extended protection against commercial misuse. So this is something which is the current framework, the current judicial understanding, interpretation with respect to emerging technologies. Now, I just want to be very clear with this aspect of artificial intelligence that in India, we still do not have a very rigid framework which would cover all these emerging technologies, emerging ventures of artificial intelligence. What we can do is we can go through the case laws, we can try to develop judicial precedents, and based on that, maybe someday the government might come up with a strong codification of artificial intelligence laws which would protect us from the misuse of AI. Apart from it, the kind of regulatory responses which we can put forward as means to protect the people, protect the society from the implication of misuse of deepfakes. We can start with the criminalization. We can focus on the harmful uses of the particular technology. For example, sexual deepfakes uh, harming a person's reputation, social deepfake videos which are impersonating a politician or creating fake speeches should actually be seen as destabilizing the democracy. All these things can be criminalized in order to create this protection from the misuse of deepfake technology. Another thing which we can do is we can regulate the platform itself. For example, if let's say something is being shared on Facebook or Instagram or Twitter, the platform itself will be responsible for detecting it, labeling it, and removing it with respect to the spread of that particular information. And that is how we can control it. And we have a DPDP Act which actually has taken into account such provisions, which has also included right to be forgotten, where if you do not want to be remembered for a certain thing, you have a right to ask the platform to remove that content. So these are some of the solutions which could be seen as a way of protecting against the harm posed by deepfake videos. So again, this requires a very multi-layered governance model, because something which is including all these aspects as solutions would require the law to actually cope up with the advancing technology. So even if, let's say, we come up with a regulatory framework, it might not be sufficient. It would lead to something which would control it a little bit, but to like regulate it on a basis which where we try to we try to control the misuse of such technologies to a vast manner. This can only be done when we have a proper AI legislation. So this is something which is about this idea of deepfake technology. Now, I would like to conclude by saying that it is not just a technological problem. It is a crisis of truth. It is a crisis of trust. It is a crisis of accountability. So the concluding uh, arguments with respect to misuse of deepfake technology would be that it undermines the certainty which we have with respect to evidences. It amplifies the existing inequalities. It actually exposes the gap in legal doctrines. And the most important and the most concerning argument with respect to this misuse of deepfake would be that it is challenging democratic stability. So when we have to respond to it effectively, we must move beyond the limited thinking which we have with respect to the existing legal framework, because now these deepfake technology, it demands an interdisciplinary response. Now we need to combine law, we need to combine technology, we need to combine ethics and public awareness, and therefore we can come up with an approach which would help us in tackling this synthetic reality which is being created by the deepfake technology. So now the question which I would like to put forward in front of everyone would be that is it possible for us to design our legal and social system to function in a world where reality itself can be fabricated? So how do we come up with a law which would not be sufficient enough to understand whether the reality is real or whether the reality is fabricated? With this, I would like to end my presentation. Thank you. Thank you so much. I would be
Thank
happy
you,
to
ma'am.
take any questions if there are any.
Thank you, ma'am. Your session on AI, truth, and future of evidence was truly thought provoking. I sincerely thank you for your insightful presentation.
Thank you.
Thank you, ma'am. Next, I am delighted to introduce Mr. Tim Fernandez, sir, a distinguished leader in the field of legal technology. He serves as the head of strategic content development for Asia at Nexus, where he plays a key role in driving innovations, particularly in AI powered legal solutions and expansion into new markets. A Six Sigma green belt with a deep expertise in legal technology and operations, he has led across borders initiatives focused on scalable AI driven solutions. I now invite Mr. Tim Fernandez, sir, to kindly address the gathering.
A very good morning to everyone. Am I audible?
Yes, sir.
Yes.
Yes.
All right.
Yes,
Yeah,
very good
today
morning.
I'm going to share with you a bit of background around technology and the rule of law. So a lot of people are talking about AI and AI as a solution and AI and what are the problems it brings. But I also want to look at what are the opportunity it brings. And I want to inspire you to actually look at how we could actually drive this. So can I share the slides? Yeah. Let me know when you can see.
Participant, kindly follow the rules. Don't unmute in between.
Hi, everyone. Can you see my slides?
Yes, sir. Yes, sir.
All right. So I'll get started with a bit of background. Yeah. So at LexisNexis, we're actually a global company. We're headquartered in New York. We have a presence in 180 countries. Our parent company is called Relics. So we have Elsevier, which is the medical arm. We have LexisNexis Risk Solutions, which works closely with the FBI and CIA on risk analytics and solutions. LexisNexis, which I'll dive deeper, which is us, which does legal publishing, which is legal solutions. And RX is the exhibition arm. So if people know Comic-Con, RX Exhibitions is the one that organizes Comic-Con around the world. So it's a very big organization with 30,000 employees worldwide. So these are some of the solutions and some of the things that we have to offer. So going on to LexisNexis, right? We have 2,000 technologists that we have. We have 3.8 petabytes of global legal content. So just to give you context, that's 170 times what Wikipedia has, right? So that if you want to look at scale of the amount of content we have, that's the amount of scale, 138 billion documents, 4 million new legal documents uploaded daily, and 29,000 new business content in 50 languages. And we have 152 million patent documents as well. So at the moment, we have currently the leading edge I would say, AI solutions in the market. We have certainly looking at a closed private model, hallucination safeguards. We can summarize, we can ask, we can analyze. And how do we know that the solutions, the answers that we give are genuine and it's free from hallucination? We give citations, we give links to the actual documents, to the actual authored documents, so that your answers that you get are actually validated by actual sources. And we also make sure that our content is reliable and the documents that you upload, if you're uploading, your client information is safe, your data is safe, you're using it with the right privacy protocols as well, and you are safeguarding your client's interests as well as your own research authenticity, right? So I'm not going to, I can do a more deeper presentation on a product at a later time, but today I'm here to inspire you on what are the solutions in terms of rule of law, right? What can we do and why do we do this, right? So just going back to our equation of the rule of law, the first step is equality. So all are equal under the law. Transparency of law, people need to be able to access the law, independent judiciary, and access legal remedy. So accessible legal remedy is actually really important. And that is our purpose, is to advance the rule of law and enabling access to justice. Right. So what do we do? So we advise judiciaries on technology adoption, developing online systems for publishing of legal content and information, advising on content management methodologies and editorial systems. We also look at the consolidation of law, creating plain language versions. So the law is sometimes hard to understand by laymen, right? How do we create accessible laws to the layman and to the general public? So developing practice guides for lawyers. There are new lawyers going into different practice areas every time. And how do we equip them with the right material? Creating legal literacy videos. So videos in terms of language and in terms of the complexity, to make it simple enough for the lay public to understand and to be able to know their rights. Creating legal education materials and capacity building and legal education programs. So I'll dive into some of the examples. So one of my favorite is in terms of missing children. So this is an area where you don't think that the rule of law, people in the law, how can we help, right? So at LexisNexis, we work with the National Center for Missing and Exploited Children in US, and we created a solution that every time a child is missing, a fax goes out to all law enforcement agencies with their photos, their details, their geographic area, and this goes out as an Adam alert, and it actually provides access to all law enforcement officers across the globe. So this is something that you can think of in the age of AI, in the age of solutions. What are the possibilities that you could do in your area, in the places that you serve? Another one is Eyewitness to Atrocities Act. So this is what we look at in terms of making sure the chain of evidence is met, right? So this app is actually developed with the International Bar Association, co-developed with LexisNexis. And this app actually controls the chain of evidence. So if you take a video using this Eyewitness to Atrocities app, the video is geotagged, it has authenticity, it has also cloud infrastructure to actually keep this evidence, and it is used by the International Bar Association primarily for war criminals. So in war-torn countries, how do we protect people who are taking this evidence, right? So to make sure that every time this is actually uploaded, it's saved out of your phone or any device. So in terms of this, it actually provides safety to those people who are reporting. And I'm happy to share that people have been convicted and have been put to jail for war crimes using this app. So in the age of technology, how do you reach the most rural areas, the most deepest, I would say, areas in a country, in places where there's no access to the internet or even computers, right? So in Malaysia, we actually worked with the courts in Sabah. It's an island in Borneo, so we actually have to go with the court. So these are court officials, National Registration Department officers that actually go deep into the village. They bring their satellites, they bring different tools to actually go into this village to register children. So these are children who can't register their birth rights because they're so far from hospitals, they're so far from actual, and they don't get access to education, access to basic medical rights because they're stateless, right? So at this point, what we do is work with the courts to actually go into the villages. So it's 4 hours by four-wheel drive, another 2 hours by boat to actually reach them, right? But each of these tables that you see in the middle picture here, it's actually a court. It's a magistrate and talking to a witness, and there's also a lawyer that's brought in to actually validate their statutory declarations, to validate their births, to ensure that their registrations can go through. So these are over 500 cases. So when you look at this, you can also think about what are some of the gaps in equality in your communities, in your areas, and how can technology help that? Next is publishing the laws of a country. So in India, you have great access to a lot of legal literature. So even at LexisNexis, we publish some of the long legacy of books like Didi Basu, Mullah, Ramaya. There's a lot of books that LexisNexis published. But in some countries, even the basic legislation is not accessible. So the Attorney General of Maldives actually reached out to LexisNexis to help them consolidate their laws because they had laws, but they didn't have a proper way to make them accessible to the public. So we worked with them on how to publish their laws in both Divehi and English, and we provided them in a platform, and now they have access to laws. Their lawyers have access, their public has access. And in Myanmar, there was also a lack of access to legal material. So in the age of AI, the age of large language models and the most sophisticated technology, you have countries where people don't know their rights, don't know their laws, and you have it being sold on the streets. And people don't even know if that's the right version or not. So we worked in Myanmar to support Myanmar's democratization process. This was way back in 2013. Strengthen parliament, support transparency of laws, and enable access. So these are some of the examples, right? There's no access to justice without access to laws. So we had workshops on constitutional awareness, organized with the Myanmar Lawyers Association, and the lawyers in turn went back to their villages and did workshops for their villages on their rights, on their constitutional awareness. So these are some of the materials that we created in Burmese, and we also created them in English as well. So in Myanmar, case reports or judgments are not published. And one of the things about investor confidence or even having people invest in your country is making sure that they have access to legal remedies. So if I invest in a country, if something goes wrong, can I go to the courts and things like that? So one of the key areas that the World Bank suggested to Myanmar is to actually publish their laws, publish their case laws. And we worked with them to actually develop a system. So it's not all the laws, but they started with commercial cases. So we actually started working with them on publishing their cases. So we looked at their materials, we developed a system, and we created a publishing system for the Supreme Court of Myanmar. And although there was a coup that happened just before we launched the project, we could see new judgments being uploaded. And we know that in the future, Myanmar's legal system will be accessible to all and will be transparent as well. So this is us at the Supreme Court of Myanmar, and we worked with them closely to actually help develop this system. And I consult on a lot of these projects on working with them in terms of how to develop a system. So if in countries where you have a system in place, it's easy to forget that this is not the norm in all countries. So in emerging countries, this is really something that's not available. And how do you build that from scratch? Right? So this is something that all of you can think about, like in areas where there's no access to laws, how do you develop that? How do you use technology to help accelerate that solution? How do you use engagement as well? So there are a lot of examples, and it's a work in progress. And one day we hope that all cases, not only their commercial cases, are published, but we've given them a framework, we've given them a roadmap for them to develop it. The next is also land rights. So we worked with the Yangon Housing Real Estate Information System. So in Myanmar, people don't know their land delineation, their land rights, their land access. And this is something that is across the country. So we created a recommendation, we created a framework, and published that with the government to help them start that in Yangon. So you can see some of the solutions there. This is pre-AI, but you can look at how much it would be accelerated through AI. And across all of these examples, right, I wanted us to come back to the why. It is because of the equality under the law, the transparency of laws, independent judiciary, and accessible legal remedy. And for to conclude, one of the things I want to remind us all, it's not about how advanced AI, we can use the most advanced large language models, the most advanced generative AI with video and audio and stuff like that. But it's not performative. It is about engaging the people that you serve, uplifting them, and making sure that the communities you serve use the rule of law to solve their problems. And I think for me, that's the message I want to share. I hope to be there in person one day to actually be able to engage more. But I hope this gives you some inspiration on how to get more solutions to the communities that you serve. That's all from my side.
Thank you, sir. We sincerely thank you for your insightful session representing LexiNexus. We are truly delighted and honored to have an international speaker like you among us today. Your presentation on the rule of law and the remarkable initiative of the LexiNexus in promoting legal awareness, accessibilities, and transparency was extremely enlightening. Thank you, sir. We are very grateful for your time and guidance.
Great. Thank you, everyone.
Now it's my privilege to introduce Dr. Monica Gussain, ma'am, a distinguished senior advocate at the Supreme Court of India and a senior executive member at the Supreme Court Bar Association. Ma'am currently serves as the chairperson of the Legal Aid, Mediation, Arbitration, and Pro Bono Subcommittee 2025-26, where she plays a pivotal role in promoting access to justice through legal aid initiatives, pro bono case allocation and collaboration with NGOs and legal clinics. She is also the chairperson of the Ladies Welfare Subcommittee, where she actively works towards empowering women in the legal profession and recently organized the impactful panel discussion titled Women Empowerment on Strength, Struggle and Success at the Supreme Court Auditorium. She's been associated with significant matters including transfer petition, that is Shubhangi Mishri Kotari versus Anil Kumar Pandey, reflecting her commitment to justice and inclusivity. Her decision to social service is evident and her active participation in free legal aid camps, including those organized by Sanjeevani NGO in Delhi. Ma'am holds a distinction of being perhaps the first woman advocate from Haryana to be designated as a senior advocate by the Supreme Court of India, and also first from the state to be elected as the senior advocate member of the SCBA Executive Committee. She was also associated with the landmark cases of Sarla Verma versus Delhi Transport Corporation, which laid down key principles for compensation in motor accident claims. Her journey is a true inspiration, reflecting resilience, leadership, and unwavering commitment to the legal profession. I now invite Ma'am to address the gathering.
Thank you. Distinguished academicians, learned counsels, my young friends who will inherit the legal system we leave behind, a very good morning to all of you. The potential benefits of artificial intelligence are huge. So are the dangers. Artificial intelligence is no longer a futuristic abstraction. It is already woven into our everyday when we unlock our phone using facial recognition, when a smartwatch analyzes our heart rhythms, or when we receive customized recommendations for news, education, or even legal content, AI is quietly shaping our choices. Apple's image based calorie calculator, health monitoring apps, predictive car features, even facial recognition systems like DG Yatra at airports all testify that AI is already mediating how we perceive the world, our health, and even our identity. But behind this convenience lies a scaffolding of data, personal, behavioral, and often deeply sensitive, that raises fundamental questions of privacy, autonomy, and equality. What is India's artificial intelligence vision? India has rightly recognized artificial intelligence as a national priority. Way back in 2018, Niti Aayog discussion paper National Strategy for Artificial Intelligence AI for All outlined a vision of inclusive AI, identifying five critical sectors: healthcare, agriculture, education, mobility, and infrastructure. The Ministry of Electronics and Information Technology later introduced Responsible AI for Youth to nurture digital literacy among students and professionals. As a founding member of Global Partnership on AI, India affirmed its commitment to human AI. Most recently, AI Impact Summit 2026 brought together developers, regulators, jurists to deliberate on central theme. Serve justice. First, we could Bar Association National Conference and with judicial governance and role of First of all, what are digital rights? The individual human rights as rights that apply in both physical and virtual spaces, from our data trails to our online identities. In essence, these digital rights are extensions of traditional civil liberties into the technological find this means familiar privacy and dignity, free expression into the language of algorithms and data ecosystems. The constitutional framework of India, pillars of our constitution are directly implicated in the age of AI are under Article 19(1)(a), right to liberty and expression, Article 14, right to equality, and 15, right to privacy, Article 21, and right to speedy Article 21 again, and right to fair trial, Article 32. That is, as far as privacy is concerned, the PUCL case 1996 on telephone tapping had already linked surveillance to Article 21, laying for due process. Puttaswamy judgment by 9-judge bench of Honorable Supreme Court updated that foundation for field work. This case was later on written in Tej Singh Mohar, Joseph Shine, Pegasus case affirmed privacy as integral part of right to life and liberty under Article 21. It emphasized that privacy safeguards autonomy, dignity, and information control. AI-driven tools, facial recognition, predictive analytics, mass surveillance, these are constantly collected, and these personal data are without consent shared by various agencies. In this manner, informational privacy becomes the first casualty of our algorithmic age. While the state invokes national security and public order, the court's proportionality test, legality, necessity, least intrusion, and proportionality remains the constitutional compass. Unchecked data surveillance risks turning a constitutional democracy into a surveillance state. Now, as far as equality is concerned, our Honorable Chief Justice of India, Justice Kant, he has said that knowledge is transformed into a constitutional instrument that enhances equality before the law. It allows judiciary to expand access to justice by all individuals, overcoming procedural barriers. Article 14 of the Constitution enshrines principles of equality before law, equal protection of laws for every individual. It serves as a foundational commitment to fairness, non-discrimination, and inclusive governance. However, the increasing use of AI in administrative processes, policing, and decision making has begun to pose serious threats to these. At the advantage of efficiency and uniformity, it also carries risk of reinforcing and magnifying pre-existing risks like caste, gender discrimination, thereby threatening the goal of substantive equality under Article 14. This concern is particularly significant as AI systems used in areas as law enforcement, welfare distribution, and predictive governance dependently on algorithms trained on historical data. Now, who creates this historical data? It is also having impact on what AI will give back to the system. The AI system trained on biased data can perpetuate social inequalities or historical prejudices in the code. Gender bias in hiring algorithms, caste-based skew in predictive policing, language bias in content moderation. Each example highlights structural inequities. When the state uses such algorithms in welfare, policing, or recruitment, Article 14 scrutiny becomes unavoidable. Now, freedom of expression. Way back in Shreya Singhal versus Union of India case, Honorable Supreme Court had already underscored that restrictions on online speech must be fair, proportional. Section 66A of IT Act 2000 was struck down therein as unconstitutional, as it is in violation of Article 19(1)(a) of the Constitution, as it punishes offensive online messages. It failed reasonable restriction test. As terms offensive, annoyance are vague, online speech should be protected unless it is directly linked to unlawful action. Now, Platforms rely on algorithmic filters to remove or amplify content. These principles extend directly into private digital architectures that shape public discourse. The IT Intermediary Guideline and Digital Media Ethic Code Rules 2021 offer limited safeguards and place disproportionate obligations on intermediaries without establishing strong user rights or AI accountability measures. AI also affects freedom of the press. This is very significant in today's world. Newsrooms are increasingly using algorithmic tools to generate headlines, curate stories, predict trending topics. While such tools enhance productivity, they also risk promoting clickbait over content quality, shaping narratives based on engagement metrics rather than journalistic ethics. More troubling is the growing use of algorithmic gatekeeping, where AI systems deployed by both public and private sectors determine what news stories reach which audiences. Such practices can divert and violate the right to receive pluralistic information, a key facet of Article 19(1)(a). For example, Indian Ministry of Information and Broadcasting has directed the PARC, Broadcast Audience Research Council, to suspend TV TRP ratings for 4 weeks, effective from early March 2026, with extension issued on March 31st, 2026, due to unwarranted sensationalization of and speculative reporting on the West Asia conflict. Many AI systems are trained predominantly in Hindi or in English, often marginalizing content in regional languages and dialects. It leads to a digital divide in expression, where speakers of underrepresented languages face systematic barriers in being heard, discovered, or moderated fairly. In a linguistically diverse nation like India, such an exclusion can be seen as a violation of Article 19 as well as Article 29 that protect linguistic minorities. Now, another angle is speedy trial under Article 21 and how AI is affecting the judicial system. Integration of AI into legal process is not without serious concern. One of the most pressing risks is the generation of hallucinated case laws, non-existent legal precedents, fake courts, misrepresented facts, and fabricated citations. A non-existent legal precedent are phenomena where AI tools produce authoritative sounding but non-existing hallucinated case law, which strikes at the very integrity of judicial reasoning. Justice Narasimha and Justice Alok Aradhe, the sitting judges of Honorable Supreme Court, have recently in a case observed that at the outset it must be stated in the clearest terms, reliance on non-existent or fabricated judgments is not an error. It is misconduct, professional misconduct on the part of the advocates, and therefore it must invite consequences. Now, this is a very serious stand taken by Honorable Supreme Court. Bench noted that the case raised considerable institutional concern not because of the merits of the dispute, but due to the process of adjudication and determination. Our Justice Dipankar Datta, sitting judge of Honorable Supreme Court, while speaking on law, lawyers, and AI, the next frontier, organized by Supreme Court Scora Association, placed the onerous duty on lawyers to verify all AI-generated content, affirming that human lawyers' responsibility is non-negotiable in the legal profession. In this situation, I agree with the Honorable Justice H.R. Khanna, who had quoted, inner vigilance price of liberty, and in the final analysis, its only keepers are the people. The most appropriate antidote to AI hallucination from legal professions is eternal vigilance. In the AI age, eternal vigilance, along with thorough verification, is the price we must pay while outsourcing tasks to AI. Equally concerning is The rise of AI manipulated evidence, deep fake images, videos, synthetic documents that challenge traditional evidentiary standards. In such a landscape, accountability cannot be outsourced to machines. Deep fakes, like in disputes of couples, WhatsApp messages when they are transcripted, fake forced translation by AI, that has to be cross checked repeatedly. In the case of Chaitanya Rohila versus Union of India, before the Delhi High Court, the Ministry of Electronics and Information Technology (METI) it submitted a status report on AI and deepfakes on 21st November 2024 in response to London petitioners' submission that every day's delay in creation, detection, and removal of deepfakes is causing immense hardships to the public at large. The London Division Bench directed for creation of a committee by Union of India to consider the regulation and statutory framework in foreign countries like European Union and take the suggestion of stakeholders like the intermediary platforms, telecommunication service providers, victims of deepfakes, and websites that provide and deploy deepfakes before report. On the occasion of Supreme Court Advocate on Record swearing in ceremony yesterday or day before yesterday at this court, Honorable Chief Justice of India, Justice Suryakant, in a notable directive, insisted that petitions should be drafted personally and not be outsourced to artificial intelligence. My Lord explicitly warned against outsourcing legal work to AI or other external parties. Deep fakes that were once tools of entertainment are today tools of deception. They challenge authenticity, undermine consent, and most importantly, they threaten the idea of evidence. AI-driven analysis of CCTV forensic data is changing is gathered, raising new issues about authentication under the BSA 2023. India, no doubt, has established a robust framework for electronic evidence through the BS Adhiniyam 2023, along with IT Act 2000 and existing criminal law provisions. However, these frameworks do not adequately address the uniquely complex problem of AI. As a result, the litigants and courts are often left without clear procedural or technical guidance when confronted with such material. Clients today, any client having an Apple or Samsung advanced mobile phone, will come with a list of case law to be placed before the advocate saying, okay, sir, even I am aware about the cases that will support my case. Now the advocate, he'll be in difficulty. If he tells the client that he's not aware of cases because maybe they are generated by AI, then the client may get the impression that my advocate is not well versed with the law. If the advocate accepts and relies on those case law, then he may be guilty for misconduct, as per by Honorable Justice Narsimha and Justice Aradhe. This gap is not merely procedural, it has serious constitutional implications. It threatens the right to a fair trial, presumption of innocence, and protection against wrongful conviction, particularly in cases involving identity theft, cyber defamation, forgery, or political misinformation. From a constitutional perspective, deepfakes place multiple fundamental rights at risk. The right to privacy under Article 21 is violated when fabricated content is created and disseminated, like revenge porn, serious breach of privacy, image-based sexual abuse. After breakup, images are shared to cause distress to the victim without consent. At the same time, any attempt to regulate such content must be carefully balanced against the right to freedom of speech and expression under Article 9, 1A of the Constitution to avoid overbroad restrictions. Right to fair procedure Under Article 21, the AI increasingly is assisted uh, in predictive policing and profiling. Lack of transparency in how algorithms classify individuals create conflict with the procedural fairness guaranteed by Constitution of India. What is the impact on victims? A victim of non-consensual dissemination report content to respective social media platform. If he files a complaint with local law enforcement and the intermediary, the content gets pulled down. It can result in psychological distress, anxiety, fear, logic of opting. Perpetrators cause serious social to the victims. More fundamentally, the increasing reliance on potentially manipulated digital evidence raises serious concerns about procedural due process. How do we test the authenticity of such evidence? How do we cross examine it? How do we ensure the integrity of judicial outcomes? Now, globally, jurisdictions such as US, UK, and EU have begun to address these challenges through evolving standards on admissibility, technical verification, and expert evidence. These developments offer important lessons for India, especially in designing safeguards around authentication, forensic validation, and legislative oversight. In the case of Raj Shamani versus John Doe, Justice Manmeet Pritam Singh Arora of Delhi High Court, she recognized known face with substantial goodwill and granted personality rights protection to social media content creator, podcaster Raj Shamani, affirming that his name, image, voice, and likeness are elements that fall under his personality rights. As a result, he has the right to seek an injunction against misuse by unknown third parties to safeguard these rights. There are numerous other cases involving art of living guru Sri Sri actors Anil Kapoor, Shatrughan Sinha, Khamosh, Amitabh Bachchan, Aishwarya Rai, Kajol, that show that courts in India have already begun recognizing personality rights against AI manipulated content to protect individuals' name, image, voice, and unique gestures. Now, what is the global perspective? Efficiency in judiciary that is dealt with in Article 21 and 32 of the Constitution of India. The countries like Brazil have deployed AI tools to assist in case tracking, screening, admissibility, and linking facts to precedents, significantly reducing judicial backlog. The app developed by Brazil seems to be doing the best globally so far. And jurisdictions of United Kingdom, Singapore are leveraging AI for case management, legal analytics, and administrative efficiency. As far as India is concerned, it has SUPC, Supreme Court Portal for Assistance in Court Efficiency, AI Saransh, platforms like Legra, legal research analysis assistant that reflect an emerging shift towards technology-assisted adjudication. Digital courts is equipped with voice-to-text features, Shruti, and translation, Panini. These functionalities are to assist the judges with order and judgment dictation, Suvas for translation from English to regional languages, making orders accessible by ordinary citizens in their local regional languages. The Supreme Court of India, in close coordination with IIT Madras, has developed and deployed AI and ML based tools integrated with the electronic filing software for identification of defects in the petitions being filed online by the advocates or petitioners in persons. The access of the prototype has been granted to 200 advocates. Supreme Court, in collaboration with this IIT Madras, is also testing the prototypes for e-filing systems being automatically file, identify defects, and instantly notify advocate to cure the defects. Earlier, this process used to take days or weeks at any given point. Now it has become a matter of minutes, curing defects by data extraction. This of identifying structured information, author, creation date, keywords to provide context, and integration with the electronic filing module, case management software, namely ICMIS, Integrated Case Management and Information System. These tools help in legal research, precedent identification, and structuring of arguments, enhancing both speed and consistency in judicial processes. To explore the use of AI in judicial domain, on 12th April 2026, a two-day national conference on judicial process re-engineering and digital transition was organized by the E-Committee of Honorable Supreme Court in collaboration with Department of Justice, Government of India at the Supreme Court premises itself. That is last Saturday, wherein the judges had come from all over the country to attend and have a streamlined, uniform system. Honorable Mr. Justice Rajesh Vindal therein had stated that AI and digital tools must be used as supportive instruments and should not be allowed to override judicial reasoning. He also raised concerns regarding the use of open source platforms that protect to data confidentiality. Honorable Chief Justice of India, Justice Suryakant, plans to implement artificial intelligence for case listing and bench allocation, reducing human involvement. This is going to have a positive benefit and effect on judicial administration of justice in India. The decision will enhance justice delivery system in India. Now, what is digital divide? Digital divide is another stumbling block in having access to justice. This divide can be between age and digital literacy, rural and urban, access to internet, global inequality, developing nations as well as developed nations, geographical gap. As India embraces AI-driven governance, we must remain conscious of a foundational reality. Ours is a deeply diverse country with uneven infrastructure. Metropolitan courts experiment with e-filing, virtual hearings, AI-assisted tools. Many district and taluka courts continue to struggle with basic connectivity and technological access. This asymmetry creates a new dimension of inequality, digital divide in access to justice. We face AI algorithmic bias. AI systems learn from that. If the historical data reflects societal bias, AI will replicate them in the results. This would directly violate right to equality in Article 14. Let us be clear that the right to access justice that flows from Article 21 cannot become contingent upon technological privilege. If AI becomes central to legal processes, state must ensure that its benefits are equitably distributed. Otherwise, we risk replacing traditional barriers with digital ones. Now, as far as speedy trial is concerned, we all are well versed with the legal maxim, justice delayed is justice denied. Our district court in India have about 5 crore cases pending. The high courts throughout the country have over 62 lakh cases, and Honorable Supreme Court itself has about 90,000 cases that are pending for it. Our current legal framework, unfortunately, was designed for static technologies. The Indian Evidence replaced by BSA still asks for certificates of authenticating electronic records. A rule is made for cloud-based AI outputs, IoT sensor data, or blockchain logs. Similarly, IT Act presumes human signatories and fixed digital certificates, concepts that fit poorly with autonomous systems. Globally and in India, courts have stretched traditional doctrines, fraud, privacy, copyright, fixed new realities as DX, but these are stopgap measures, not sustainable. India does not currently have a dedicated AI legislation akin to the EU's AI Act 2024 or Canada's Artificial Intelligence and Data Act 2023. Our existing laws as IT Act 2000 and the recently enacted Digital Personal Data Protection Act 2023 offer partial coverage, but short of addressing the unique risk posed by autonomous systems, algorithmic decision making, and opaque data flows. Moreover, sectoral regulators such as SEBI, TRAI, RBI have issued non-binding guidelines or discussion papers on AI use, but there is no central statutory authority overseeing AI regulation. The Niti Aayog's National Strategy for Artificial Intelligence 2018 emphasized AI for social, but it did not engage sufficiently with rights-based concerns, focusing instead on economic and innovation imperatives. This jurisprudential gap risks normalizing technological arbitrariness and undermining the rule of law. India also suffers from a fragmented data ecosystem. With multiple government agencies collecting and using data, often in opaque or insecure ways, risk of functioning surveillance and mission drift are glaring. What is the way forward? AI operates through probabilistic pattern recognition. It can organize, summarize, correlate data, but it does not understand suffering, intention, remorse, fear, dignity. AI lacks human empathy, compassion, reasoning. Our goal is not automation, it is augmentation. India's constitutional jurisprudence, especially through landmark decisions like nine-judge bench judgment in Puttaswamy, that has unanimously recognized privacy as fundamental right in Article 21, that is informational privacy, and laid down the need for new law with regard to data privacy, expanding scope of privacy in personal spaces. Shreya Singhal judgment, Anuradha Bhasin judgment on freedom of speech, expression, trade, internet being protected by Article 19(1)A and Article 19(1)G of the Constitution, wherein it was the indefinite shutdown of internet was held to be unconstitutional. These provide the doctrinal tools to regulate AI meaningfully, but the application of these doctrines to algorithmic governance remains nascent. There is an urgent need for both legislative and judicial institutions to proactively safeguard in the AI age. As we move toward widespread digitization, from smart codes to predictive governance, the challenge is not to resist technology, but to institutionalize it. We need to explore how AI can be combined. AI can suggest, but the human decides. We must navigate it with AI remains a tool of sense and not a tool of substitution. The Constitution must not follow technology. Technology must follow the Constitution, be it in its budding stage and also in future ever and ever, for the Constitution of AI is supreme. In the words of Baba B.R. Ambedkar Sahab, Constitution is not a mere lawyer's document. It is a vehicle of law, and its spirit is always the spirit of age. Constitution is supreme. Jai Bharat, Jai Maharashtra. Hind.
On behalf of everyone present here, I sincerely thank you for your insightful sessions. Your discussion on various cases related to AI was extremely informative. You have helped us in understanding the practical and legal dimension of this evolving field with great clarity. We are truly grateful for your valuable time and knowledge. Thank you, ma'am.
Thank you.
Thank you so much, ma'am.
Now it's my honor to introduce Dr. Marcus, who has joined us today as an international speaker from the United States, a highly accomplished academician and a legal professional. Sir is a professor at the law at Amrita's School of Law, Coimbatore. He holds a Juris Doctor from the University of Pennsylvania Carey Law School and a bachelor's degree from the College of William and Mary. He was admitted to the New Jersey Bar and has also served as a law clerk at the Appellate Division of the Superior Court of New Jersey. With over 15 years of legal practice in the United States, his expertise span environmental law, corporate law, and civil rights. Now, I invite Dr. Marcus Romano, sir, to kindly address the gathering.
Hi, everyone. I'll just start by saying my connection may be unstable, so I might have to shut my video off because that will help me. The internet connection here is not very good. But that being said, Namaste Bhai, everyone. Distinguished delegates, respected scholars, and fellow participants, it's truly an honor to speak at this global platform where ideas from different fields come together. Today, I want to talk about something that sounds technical, but is actually quite human. How bias underpins AI's conclusions and can have the potential for rising to the level of unlawful discrimination that's harmful to individuals and can be actionable under the law. So let me begin with a basic question. If AI is created and programmed by humans, can it ever be free from human bias? Since AI systems make conclusions based almost purely from gathering data, and that data is collected by humans and reflects societal mores and norms, which are not always equal, it will be very difficult, if not impossible, for AI to avoid reflecting biases inherent in our societies. So while AI may be intelligent, quote unquote, efficient and effective, we have to ask if it's also going to be fair. Perhaps more interestingly, at least for me as a lawyer, we can ask, will the results that AI produces in certain circumstances, for example, when used by employers in decisions relating to hiring employees, will that AI always accord with the standards set forth in laws that prohibit discrimination based on an individual's membership in a protected class? And that is one of the themes that I'm going to discuss in detail here in this talk. Now, it is a little bit important to consider how bias enters into AI's choices. There's a number of ways that it can do this. First, the data itself can be biased. And this relates to the concept of data determinism, where the quality and nature of data directly determines outcomes. If the data is based on inequalities in society, which it frequently will be, the AI's conclusions will also foster inequitable and sometimes discriminatory results. Second, bias can creep in through software design choices. This is the value-sensitive design theory, which argues that technologies reflect the values and priorities of their creators. If fairness is not a priority during design, it likely is not going to appear in the outcomes. Third, a lack of diversity in design teams. This is related to standpoint theory, which suggests that people from different social positions have different perspectives. If the AI development team lacks diversity, certain problems in the criteria used for data selection could go unnoticed and ignored. Now, to dig a little deeper, let's focus for a bit on gender bias in AI, which means that technology treats people differently based on their gender, often without us noticing. In simple terms, it is a form of algorithmic discrimination, where decisions made by machines are influenced by social patterns that reflect inequities in society. One useful way to understand this is through the idea of bias in, bias out, a concept that's often used in data science. If the data AI uses to reach its conclusions is based on already existing inequalities in the system, the outcomes have no choice but to reflect those inequalities. They even have the potential to amplify them if the algorithm is designed in certain ways, focusing on specific factors that might relate to a right protected by law. For example, an individual's membership in a protected class. This concept is closely connected to the sociological theory social reproduction, which explains how existing inequalities in society get repeated over time through institutions. Now, these same inequalities appear to be being replicated and perpetuated through the use of AI technology. As an attorney and law professor, this begged the question for me. If the algorithms AI is instructed to use result in companies making decisions that violate anti-discrimination laws, will the law allow individuals to bring suits challenging the use of this new technology as violative of their rights under the law? And how will those suits look? How broad will the rights be, and to whom could those whose rights are being violated challenge? So in addition to the kind of explicit bias that can occur in the data that AI employs when reaching its conclusions, there's a stronger potential for implicit bias to seep into AI's work. This is so because even when developers of the programs and algorithms AI uses do not intend to discriminate, their assumptions and the historical data upon which they rely may carry hidden biases. These biases become embedded in algorithms and make them appear neutral while actually producing unequal outcomes. Again, and this is something called disparate impact that I'll discuss a little bit more. That's a cause of action in the United States as I address what the United States has been doing to tackle these types of problems that are coming up in hiring using AI platforms. Now, again, using gender as an example, recently, feminist scholars have argued that technology is not neutral but socially constructed, meaning it reflects the values, norms, and power structures of society in which it is created. This is why AI systems often mirror gender stereotypes, but they can mirror stereotypes for a member of any protected class. It could be race, age, religion, gender identity, sex. All of these are, or any number of protected categories that you can think of. We can find stereotypes if the AI developers don't flag these issues when creating the software. Now, choose the country and the attendant societal bias, for example, race in the United States, and direct AI to make selections based on data that emanates from historical decisions rooted in those biases, those that adhere in the data. And the results will always be decisions that are biased by their very nature. Looking again at employment as an example, if a company that is asking AI to guide it in hiring new employees and uses its algorithms data from the company and other companies in that sector in the relevant country chosen randomly from sources in AI's pools, the results will inexorably accentuate bias against, in this example, members of a certain race that has historically not been successful in the company's field, because those sources AI uses invariably carry implicit bias against people of that race. This is actually happening today, right now. For example, a few years ago, a major global tech company had shut down its hiring AI system because it was favoring male candidates based on the AI's instructions to utilize past hiring data where men were hired more frequently than women. The AI simply learned this pattern and continued it. This is a clear example of historical bias, a sort of implicit bias where past discrimination becomes encoded in modern systems. Here, in the interface between the data that the AI pulls from the algorithms it uses to make decisions. Now, courts in the United States, and this is where my expertise comes in, just from having practiced in the United States and done regulatory work there for many years. So I'm going to talk a bit about what the United States has been doing as an example, a potential example for ideas for international regulation, noting that other countries are doing taking a lot of positive steps to work on creating fairness in the use of AI and making AI making a situation where AI is going to comply with the laws and constitutional guarantees of rights granted in all these different countries. But courts in the United States are starting to address this problem in the algorithms used by AI companies. And here we're going to use the example of employers making hiring decisions. And they're doing so because these hiring decisions are made often without a human even reviewing the data to ensure that the choices are not violating United States anti-discrimination or other laws. Now, there's a number of examples of this, and it's started about 2 or 3 years ago. The courts in the United States have recently, and this is one of the most fascinating cases that has come up, and it was a few years ago, have recently entertained a class action suits against companies for using AI in the hiring process for violating federal and state anti-discrimination statutes. In a case called Mobley versus Workday, Inc., a federal judge in the state of California certified a class action lawsuit against Workday, which is a major AI-driven applicant screening platform. The plaintiff, Derek Mobley, is an African-American man over the age of 40 who alleged that he was rejected by hundreds of jobs that used Workday's AI because of his race, age, and because of a disability bias. The court ruled that Workday could be held liable as an agent of those employers and that the AI tool acted as a unified policy that harmed job applicants over 40 nationwide since September 2020. Now the case is still ongoing, and class action suits in the United States have a huge amount of discovery. There's tons of evidence that will be pulled out, and I'm sure we're going to find out a lot more about how these AI platforms are developed, and then whether there are ways to change the development process to take into account both implicit and explicit bias to prevent situations like what happened to Mr. Mobley and all these other people who were affected by the Workday platform. And so this is a big step in the direction of compelling not just the companies that use the screening platforms, but the actual vendors who make the platforms, compelling them to be conscientious and also conscious of the law when they're when they are creating AI platforms that, in this case, again, relate to hiring. And just to step back, there is omnibus civil rights protection in the United States for protection from discrimination in the hiring process. So I didn't mention that, but that's why this is happening, because the law prevents employers from discriminating based on membership in a protected class in the process of hiring. Now, there are a few other neat cases that were going on, some that give us a couple more, and then I'll talk about kind of ideas for how we can work on correcting this, and also and so in Harper versus SiriusXM, an additional case, the plaintiffs alleged that SiriusXM's AI hiring system discriminated against African American applicants based on race by using proxies like zip codes and educational history, resulting in automatic rejections of numerous African American applicants. This is a complex cause of action that focuses on apparently neutral evidence that shows implicit bias against members of certain legally protected categories. On their face, the area where somebody lives and their educational background have nothing to do with their race. But in effect, in the United States, certain areas represented by zip codes are predominantly African American. And statistically speaking, African Americans are less likely to attend university than people from other races. And so what we see here is that the application of the AI-powered hiring system has what is called in the United States a disparate impact upon people who are of African American descent. And what that means is that there doesn't have to be intent to discriminate, but because there actually is a discriminatory impact, there's a cause of actions for discrimination. And usually disparate impact cases are sort of class action cases. There are many, many people being impacted by the same decisions. So a lot of these class action cases will be disparate impact cases. And this is a cause of action that is less frequently used internationally, that the United States can kind of hold up as a really good standard for a cause of action that can really help with issues in employment discrimination, especially that will arise with the use of AI. Now, still, because the determinants that the AI was using in this case, in the Harper case, are facially neutral, the factual underpinning of the suit begs the question: how can developers create AI algorithms that take into account relevant employment data, like what level of education someone has completed, while at the same time not potentially discriminating against applicants based on their membership in a protected category? And this is really important because when you're hiring, you want to know, has someone gone to university? But in this case, is that, should the algorithm consider what weight should that be given in the algorithm? It has to be given some weight. It is valuable information, much more valuable information than the zip code showing where they live, which actually is completely irrelevant to the hiring process, except in the context of commuting to work. But really, education is extremely important in hiring for most jobs. So this is not a question I have an answer to, but it's something that's going to have to be addressed, because the company could argue, well, while it's having a disparate impact, there's a legitimate business reason for looking into the level of education an applicant has. And if we screen based on that, well, that's okay because that's part of our business. And this is kind of a defense that the companies can come up with. And so what balance can we strike to ensure that these AI algorithms are protecting the business's rights, but at the same time, not having an unnecessary disparate impact on members of different protected categories. Now, another early on case, which is the EEOC versus iTutor Group, was 2022, 2023. Again, this has been going on for a little while in the United States, these suits. This was the first lawsuit brought by the United States federal government's regulatory body that enforces Title VII of the Civil Rights Act of 1964. That's the United States Omnibus Civil Rights Employment legislation. And the Equal Employment Opportunity Commission, the EEOC, claimed that AI hiring bias rose to the level of a failure to hire based on a protected characteristic in violation of Title VII. And this case settled pretty quickly in August of 2023, and the company paid $365,000 to a pool of applicants over 60 years of age whom its AI screening tool had automatically rejected. So this was early on in the process, and it became clear to companies that they couldn't use platform that simply rejected someone based on a protected characteristic. They had to have more than that. So, or had to have maybe age as a factor, but not as a determinative factor. Now, iTutor Group also promised to update its software as part of this. So we see not only did they have to pay, the government frequently makes you pay fines and pay out to the complainants, but also they had to do some additional work in correcting the problem. And the government, in its role in the United States, would have spent time ensuring that occurred, and then monitoring iTutor Group moving forward to ensure that they continue to complete the hiring process using software and techniques that were legal. Now, another interesting question arises here. If the software was developed by another company, should that developer be liable for creating an algorithm that violates civil rights laws? And we know from the first case that I discussed, the Workday case, that the United States courts are starting to use agency law as a means of bringing in the developer and trying to attack the problem at its root. And I think this is a great idea. I think this is one of the things that has to start happening internationally. We can't have companies that are violating laws. We can have them be held liable as well. They should also be responsible in the way that they use a platform or knowing the platform they're using. But the developers are the ones who can actually fix the problem because they're the ones who create the algorithms. So now there are cases alleging that using AI in the applicant screening process and interview process causes of actions other than discriminatory failure to hire. So just a couple other things that are going on in the United States. An ACLU complaint versus HireVue and Intuit, a United States NGO, which is the ACLU, joined up with the EEOC and the state of Colorado's Civil Rights Division and filed on behalf of a deaf applicant, alleging that the defendant's AI video interviews did not provide proper accommodations and were inherently biased. Here, the additional claim is for failure to accommodate a disability. Some questions arise with this too. Can developers create an AI tool that resolves this issue on its own? Are we seeing situations where AI has to work with people? Here, members of the company's human resources would be the people that AI would work with or that would use the AI in order to be used in a manner that comports with the law. Where is the line in the sand? How can we maximize the usefulness of AI as a tool for efficiency and at the same time treat human beings correctly, or in this case, legally? And there is a moral side to this, not just a legal side, although I'll be addressing primarily the legal side as we're not going to get into philosophy in this particular discussion. Now, the last case I'll mention here, just because it also shows that there's some variety in the laws that AI is violating, is there's a case called Kistler versus Eightfold AI Inc. And it's another class action AI lawsuit. And if I didn't explain it at the beginning, class action suits are ones where many people have the same cause of action, and the courts in the United States, for purposes of efficiency, have forced people to join classes and all bring the same suit. That way, the defending client, the defending company or entity has only one case to put on, and all of these people will be represented in the class. And if the class wins, everyone gets some sort of remuneration, and if it doesn't, then they all fail. You can opt out of a class and bring your case, but usually doesn't happen. And although I'm not going to speak too much on class actions, they have many of their own pitfalls, but they are a way of, because of how expensive they can be in the damages, of getting companies to really open their eyes about making changes to prevent these similar types of violations from occurring, where they're going to have to pay literally millions and millions and millions of dollars to a whole class of people. It could be up to 1 million people. And so, no. I'm giving a speech. I'm so sorry right now. I cannot speak. Please, I am giving a talk right now. Sorry, someone was at my door. So here the AI suit, class action suit, or the suit against Eightfold's AI, which ranks applicants, the AI was ranking applicants on a 0 to 5 scale and violated the United States Fair Credit Reporting Act by collecting data without consent and failing to provide necessary disclosures. This case focuses on privacy and black box decisions, meaning they check a box on a application. That means that they're not going to pass in the applicant process, rather than just discriminatory outcomes. So in this way, it opens the door for the law to look into the algorithms that the AI tools use when ranking and rejecting candidates. This lens can help attack the problem at its root and possibly lead to the development of AI tools that account for bias as part of the algorithm use. From these cases, we're starting to see different ways that the law can be used to break down bias and discrimination that inheres in AI algorithms when developers lack awareness or purposefully design tools for hiring that rely on data that has a disparate impact on members of certain protected categories. Perhaps most importantly, in the United States system, courts are exploring holding vendors, the actual AI developers, directly responsible if the tools they develop and sell that help employers with making final decisions in the hiring process are violative of anti-discrimination or other laws. Courts are becoming more comfortable with treating vendors as agents of the employer. This is perhaps the most efficient and effective way to ensure that AI tools are not violating anti-discrimination and privacy laws, because it forces developers to think of criteria that are explicitly and implicit, that avoid explicit and implicit bias that may have a discriminatory impact on candidates in the hiring process. The developers are then able to create an algorithm that does not use those discriminatory factors in the hiring process. It is most important to understand the idea of disparate impact that AI algorithms can have on certain protected populations. AI models often use proxies for protected characteristics, that is, graduation year for age or zip code for race, which in the United States constitutes unlawful discrimination if it results in less people from a certain protected class receiving proper protections under the law or having their rights violated. In our example, using certain proxies results in more people from certain protected categories not being hired, which means there is a disparate impact on those individuals based on their membership in protected categories. This is a cause of action that will be important for other countries and international bodies to consider in relation to AI bias and discriminatory impacts. Now, another neat point in the United States is that there's starting to be a regulatory focus on this. New York City, through Local Law 144, the state of Illinois and California have all enacted or are implementing strict regulations requiring independent bias audits of AI tools, with New York City requiring public disclosure of the results. So we're starting to see movements toward the government being much stricter, and I know this is happening internationally as well. In the global legal world, governments are slowly catching up with AI as well, and it is slow in the United States too. They're not going any faster. They're just the United States court system is tackling it, starting to finally tackle it more aggressively in the last year. Now, General Data Protection Regulation, GDPR in Europe, talks about fairness and gives people the right to question automated decisions. The EU AI Act is one of the first major attempts to regulate high-risk AI systems. And in India, the Digital Personal Data Protection Act of 2023 is a step forward, though I think there's still need in all of these situations for clearer rules specifically targeting algorithmic bias. And employment is just one of the many areas of life in which bias in AI algorithms is impacting individuals negatively and potentially violating the law. It's just what I chose to focus on in this talk. Now, law can help in two main ways. It can help by protecting people from discrimination and by making companies accountable for the use of AI, for unlawful use of AI. But the law is not going to be sufficient to solve this problem. Technology will move faster than regulation, and it has been, as we can see, as we're constantly catching up. So we also need ethical responsibility from developers and companies. Truly, the developers need to be incentivized to make changes in the AI algorithms that result in fair, just, and lawful application of and results from these tools. There are some steps that companies are taking, in part due to litigations arising in the United States, and then in part due to other laws that are coming up in the global economic world. Employers are being urged to, one, conduct independent bias audits on AI tools before and after implementation. Two, maintain human oversight to review AI-generated rejections to ensure that there is no disparate impact, and using hiring as an example, again, to ensure that there's no disparate impact in the hiring process, but generally to ensure that there's no violation of the law. And three, ensure transparency with applicants regarding the use of AI as a hiring tool if we're focusing on hiring. Now, all of this begs the question of whether we can use AI ethically in something like the process of hiring employees. In simple terms, ethical AI means building systems that are fair, transparent, and inclusive. It means asking questions like, who is being left out, who might be harmed, and how can we fix it? In addition to what companies are doing already to protect themselves from litigation, there are a few other ways in which developers and companies can help promote fairness and integrity in the use of AI in the hiring process and in other parts of life. First, we need better data that represents everyone fairly, regardless of their membership in a protected class. With the way that the internet exists today, that may be difficult to achieve, but perhaps broader searches and designing algorithms that reach out to data outside of what they might normally reach out to for certain specific issues might be a way to do that. And then the AI has the filtering process will be important. And on the tech side, I'm not so strong, but I'm sure there's a way to develop an algorithm that can pull from data that's more equitable. Second, we need, especially where there's awareness of these inherent biases that exist in data. Second, we need regular testing of AI systems to detect bias. Perhaps the governments can be involved in this process more actively as they're starting to be. Third, we need more diversity in tech teams, especially more women and people from different backgrounds. Fourth, governments must create strong and clear rules. And finally, users like all of us must become more aware and question the technology that we use. This is exactly why this conference, Artificial Intelligence Nexus, is so important. AI is not just about coding. It's about how we develop in a society. We need lawyers, sociologists, policymakers, and technology experts to work together along with the governments. Only then are we going to be able to build systems that are not just intelligent, but also just and accord with the mandates set forth in the laws that govern our societies. AI in some way will be a mirror of society. Maybe one day it will think on its own, but right now it truly is simply a mirror of what we are and what we have put out into the world through the internet. And if we do not fix the biases in our world, they will appear in our machines and they will appear in the decisions made based on what those machines tell us. But at the same time, AI also gives us a chance to correct those biases and build a more equal future. So the real question is not whether AI will shape society because it already is. The question is, what kind of society do we want AI to create? And that is where we as policymakers and educators and lawmakers and just people living in society have a chance to make a change. Thank you very much for your time.
Thank you, sir. This perspective truly made us reflect deeper on the ethical and legal challenges surrounding AI. Your insights were not only informative but also intellectually stimulating. Thank you for raising such a thought-provoking question that if AI is created by humans, won't it be inherited human biased? We are grateful for your valuable contribution and for encouraging us to think critically. Thank you. Now, it is an honor to introduce Dr. Gururaj Devarhubli, sir, an esteemed academician and legal researcher currently serving as an assistant professor of law at the Institute of Law, Nirma University. Sir specializes in intellectual property rights, criminology, and criminal law, and has made significant contribution to legal scholarship through his research and publications. His work has been widely recognized, with papers published in reputed journal indexed in Scopus, Web of Science, and UGC and K, and presentations delivered at numerous national and international conferences. He also serves as an associate editor of the Law, Criminology, Criminal Studies section of Content Social Science, published by the Taylor and Francis Group, reflecting his strong presence in global academic discourse. In addition to his editorial role, Sir is a reviewer for several prestigious publications. Further strengthening his academic leadership, he serves as an editorial board member of the ILE Intellectual Property and Corporate Law Review and as a senior editor at Beyond Briefs Law Review. Through this extensive academic, editorial, and research contribution, Sir continues to play a vital role in shaping contemporary legal thoughts and advancing legal scholarship. Now I request Sir to address the gathering.
Thank you, Ms. Janvi, for the introduction. Good morning to all, and I'll be starting with the presentation which I'll be making today. I hope the PPT is visible. The topic on which I'll be discussing today is about the AI Nexus, owning intelligence and protecting innovation. Now, the reason why this topic needs to be discussed is basically we are very much aware that AI is something which has brought intelligence across different fields, whether it is medicine, engineering, finance, or art. But one area which which AI has not been able to bypass is basically the law field, the legal field. And there are certain issues which are still not properly addressed and which have been though discussed by different scholars and different at different platforms. But the area is still lying in a very gray area, and the problem is that a proper framework is not provided with respect to AI when we are discussing those issues. The major issues which are coming up with respect to AI and the intersection of law and AI is, first of all, who owns the output? First of all, the first issue which needs to be discussed is who owns the output. Second is who is liable for the mistakes committed by AI. And the third is who and how do we protect human creativity without stifling machine learning? So over the next 20-25 minutes, I'll be discussing on these three areas, and I will be providing as an expert of IP and innovation law, the intersection about the use of AI and how if AI will be useless if we do not address these three areas which I have mentioned. So this would be the flow of the presentation. We will be starting with the introduction to the fundamental legal tension which is existing between AI, which AI creates. Second is then I will be explaining the materials and methods which are adopted in this particular presentation to come up with the conclusions. The second is because I am from IP, so I will be covering. I have covered the certain statutes which are existing, the case laws, and the comparative legal analysis has been done. Then next is we will be discussing four critical flashpoints in this presentation. The first is the training data copyright. Second is AI authorship. Third is liability for hallucinations, and the fourth is the global regulatory split. So finally, I will be presenting my conclusion and offer actionable suggestions for different stakeholders. So with this, I'll be starting with the introduction. Now let me frame the problem as such. Generative AI models here, if you see, learn by ingesting a massive amount of data, which has been given as the input, which can be either books, images, code, or music. That data which is created by humans, that data is fed to the AI system, and the AI then produces outputs which are sometimes complete directly with those which directly compete with those which are created by human works. So the current IP laws existing in different jurisdictions, like under the US, it is the US Copyright Act of 1976. In Europe, it is the European Patent Convention. In India, it is the Copyright Act of 1957. All these three jurisdictions assume a human author or inventor. They do not account for a system that can generate 1,000 of um, patentable molecules in an hour. Now, this creates a legal vacuum. Now, in that vacuum, what has happened is there are litigation which have is also an innovation which has slowed down, and also there are small players which are getting crushed and which are being neglected because of this particular system. The introduction is simple here that AI forces us to rethink the very foundation of intellectual property. So how do we reward AI innovation while also protecting the rights of the human creators? That is the dichotomy which needs to be addressed. So in order to understand this, the materials and methods which have been presented, which have been used by me, are basically uh, uh, the materials are primary legal sources such as statutes existing in US, Europe, and India, the regulations which are existing in these three jurisdictions, and the landmark court decisions decided by the courts of these three jurisdictions. The unit, I also will be reviewing the pending cases which are still pending before the courts, like the New York Times against OpenAI. Now, the method, as it is comparative in nature, what I will be doing is I ask how each jurisdiction treats the same fact pattern. For example, using copyrighted books to train an LLM, that is a large language model. Finally, I apply the incentive theory. And how does it propose a legal rule which makes AI development more likely or less likely? This is not abstract philosophy, but it is the same test courts use when deciding IP cases. Now, let us discuss the battlegrounds. Coming to the discussion which is there, the discussion has been divided into four parts. Part one discusses with training data and copyright. Part two discusses with authorship and patentability issues. Part three discusses with the liability and global divergence. And the other aspect, part four, discusses with trade secrets and transparency. Coming to part one basically is concerned with training data and copyright. Now, here, our first discussion point is basically to AI data training. When an AI company scraps the entire internet to build a model, is that theft or it is progress? In the United States, fair use doctrine considers four factors. The most important is transformative use. In the Google Books case, scanning millions of books to create a search index was held transformative because it did not display the books for reading, but generative AI does something different. It can reproduce a near verbatim copy of a New York Times article when prompted. This is not a transformative, it is competition. So the European Union, however, takes a different path. They create a specific exception for text and data mining, but for commercial AI, right holders can opt out. This means that companies like OpenAI would need licenses. However, China, interestingly, is still silent but has mandated deep synthesis watermarks. So the conclusion here is if we are building an AI, assume that unlicensed training data will eventually be deemed infringement. Now, for that, a clean data set is to be kept. For policymakers, we need a clearer global standard because that will help us to decide the policy at the local or at the national level. And also, perhaps we need a compulsory license with reasonable royalties. Now, without it, any of the companies, which is the highly ranked companies, also can afford to litigate. This is the first part which needs to be, which was discussed here. Now, coming to the second discussion area, which is relating to authorship and patentability. For this, for the second part, who is the author or inventor? Right now, every major patent office says only a human can be a patent holder. A natural person can be a patent holder. In the Theller case, Dr. Theller listed his AI system Dabus as the inventor. The US Supreme Court refused to hear the appeal, letting stand the ruling that an AI cannot be an inventor. For copyright, the US Copyright Office said the same. A completely AI generated image cannot be registered, but here is the nuance which needs to be seen. And if a human substantially edits, selects, or arranges AI output, that edited work may be protected. The problem is that for many high value AI applications, drug discovery, semiconductor design, the AI does 99% of the work. If that output cannot be patented, companies will either keep it as a trade secret, which is highly risky for them, but also, or they may not invest in trade secret at all. This is a failure of the invention policy. My suggestion is to create a new shorter term protection for AI generated inventions. For example, 5 years instead of 20 years. Now, this shorter duration gives a head start without locking up human progress forever. Discussion third, which basically covers liability and global divergence. Here, the final discussion point here is liability. Now, imagine a scenario where a hospital is using an AI diagnostic tool that misses a tumor. The patient sues. Now, who would be liable here? The doctor who relied on the AI, the hospital that bought the AI, the developer whose training the data was incomplete, or the courts which have to decide such issue. Now, when the courts are deciding such issue, the problem is the EU AI Act tries to solve it by classifying the risk, either high risk AI, like medical devices, which require third party conformity assessments and post market monitoring. Now, if you fail, fines up to 35 million pounds can be imposed. The US has no such law yet, but the FTC has already used its unfair deception authority against AI companies. China, on the other hand, has also mandated the deep synthesis, which must not spread falsehoods and must have visible watermarks. The practical effect is global fragmentation, because when we are talking of the practical implications of this divergence and conformity, the problem is that a company which works to sell in all the three markets, whether it is India, Europe, US, or China, it must comply with the most stringent rules, typically of the European Union. Now, this is not necessarily problematic, but it raises the standard of the quality which needs to be complied by AI companies. But it is also raising the cost which needs to be mandated and which needs to be seen, and which may lock out startups. So a small startup may not be able to match up to the scale, because of which it may be out of the market. So here on this particular issue, my viewpoint is that we need international harmonization through a model law, perhaps through WIPO. And until then, AI companies could design the AI for the highest standard. The last area for discussion is related, which is trade secret and transparency. This is a related area, but it is also a critical area which cannot be kept separate. Trade secret AI models are often the crown jewels of tech companies. They do not want to disclose their training data or weights, but also consumers have the rights under GDPR. You have the right not to be subject to a solely automated decision that significantly affects you. and you have the right to an explanation. So how do we reconcile this? How do we maintain that trade secret is also not being hampered, and also the AI companies are also not losing the protection over the training data set? In that particular case, the answer is explainable AI, which means that techniques that produce a human readable reason for an output without revealing the underlying code. For example, what happens is you have applied for a loan. Your loan has been denied because your income was below the threshold limit. In that particular case, that does not mean that the entire model would be exposed. Instead, the courts are also willing to and issue protective orders. Now, what will be the purpose of these protective orders? These protective orders will be basically the algorithm is shown only to an expert witness who is bound by confidentiality. So your application will be scrutinized only by a team of expert who is scrutinizing that particular application. So trade secrets are also not an absolute shield. If you are a developer, build an explanation layer now, so it will save you from litigation. So based on this, the four key findings which can be made is, first of all, the first conclusion is training data is the biggest legal exposure. You have to assume that scrapping without permission will eventually be held infringing. Second is the current IP system fails to incentivize AI generalized inventions because it refuses to grant any protection. Third is liability is a patchwork. The EU AI Act is becoming the de facto global standard. The fourth point is transparency is achievable without sacrificing the trade secret through explainable AI. So collectively, when these four findings are clubbed together, the conclusion is basically that we cannot simply stretch 20th century copyright and patent laws to fit into the 21st century AI inventions. We need a new purpose-built rules. So the nexus is to call for legislators, judges, and innovators to build a legal system which matches the technology. So based on this, what are the suggestions which I have provided? The suggestions are basically, first of all, for the legislatures. Second set of suggestions are for the courts. And the third is for innovators like the AI companies and the users. And the fourth is for the international bodies like WIPO and WTO. For the legislatures, the suggestion is basically do not force AI outputs into existing patent or copyright boxes. Create a new limited right, perhaps 5 years of protection, renewable only if the output is significantly modified by a human. Now, what happens through this is it gives a head start without creating perpetual monopolies on machine generated content. Second set of is for training data, creating a compulsory licensing model. AI companies pay a small fee into a collective rights pool, which distributes to copyright holders. This avoids endless litigations. The third is for the courts. You do not hold AI liable for every statistical correlation. Instead, the liability should only be attached when the output is substantially similar to that of a specifically protected work. The fourth is for developers. It is required that they should audit their data, keep the records, and if you cannot prove where your training data comes from, you cannot defend a lawsuit. Finally, for WIPO and for WTO, it is required that they should start with a treaty process. The internet has taught us that global problems need global rules. So let us do not repeat the same mistake with AI that we keep the legal framework related to nationals only. So instead, the suggestions should be actionable, balanced, and pro-innovation based. So with this, I would like to conclude that the law is not a barrier to AI. Instead, it is the scaffold that allows the AI to scale safely and fairly. So with this, I conclude my presentation. Thank you for patient listening. And if there are any suggestions or comments, I'm open to them.
I sincerely thank you for your insightful session on the AI Nexus, owning intelligence, protection, innovation. Your explanation to the legal challenges of AI, that especially regarding authorship, liability, and innovation, was truly enlightening. You have helped us to gain a deeper understanding of this involving area of law. Thank you, sir. Now, it is my pleasure to introduce another international speaker, Mr. Mohammad Anas Khan. He is a researcher and the project manager at the University of Manitoba, Canada, whose works lies at the intersection of justice, regulatory governance, and research ethics. He works on the global food system with a focus on small-scale fisheries and informal value chain across South and Southeast Asia. His works also explore AI ethics, particularly how data-driven systems can be impact equity and accountability. I now invite Mr. Mohammad Anas Khan sir to kindly address the gathering.
Thank you, Janvi. I appreciate that very generous introduction. And also thank you to the organizers, Dr. Madhura and also Dr. Salve, who's coordinating it. I appreciate the invitation and I'm very honored. Before I begin, just one important disclosure, and I was very keenly listening to the presentation of Dr. Devarobli, which was very insightful. My primary area of work is not AI. I mean, of course, like some of us are still trying to evolve, based on how the world evolves around us. I am someone who's very much rooted in governance, issues of human rights, and that's where I'll dovetail from. So I delivered a similar presentation a week ago. Post that, I had a whole week of reflection on what more could be done. And in my presentation today, which I will share with you in just a moment. Okay, I'll have to have someone. Okay, can you see my screen now? Is my screen visible? Anyone?
Yes, sir.
Awesome. Thank you for confirming. Right. So in my presentation today, I will primarily be talking about the two major themes that were reflected in the brochure on governance and human rights. But then they'll also be cutting across other issues such as technology and possibly education. But with education, you'll have to make that link. And my presentation, unlike Dr. Devarobli, it's a very intense, detailed, research-based presentation, would primarily come from reflecting on governance and human rights as I see AI evolving, and some of the questions that I think will be interesting for the participants in this conference as they reflect on their own presentations and work. Again, AI is pretty much a work in progress. It is evolving very fast, and that's how technology is in our modern age. But before I go into the details of my presentation, I think it's important to share some opening thoughts, which are of course my opinions, and I think based on these opening thoughts, then I will talk about some principles that kind of emanate from these thoughts. Number one, again, artificial intelligence, you guys, all of you know, is a technological innovation. It is not just reconfiguring the markets. And that's the point I am focusing on, but it's also reconfiguring the relationship between citizens and the state, and the citizens with each other. So how do constitutional safeguards? The Constitution essentially, in a very crude language, is a contract between the citizens and the state. How does that impact this relationship? And what should be the response, when AI comes into the domain of constitutionalism? So this is again a more jurisprudential question, abstract in the sense that it is really looking at the possibilities, but very important from a risk assessment perspective. There are ample of opportunities with AI, and some of us have to really appreciate how it has made some of our work pretty efficient. It has made us more, I would say, productive, but in not in all cases, right? Sometimes there is a cost to that productivity. And then, however, with these opportunities, and again, going back to being a lawyer again, there's a need to stay grounded in its application, especially for delivering public good. Some of you might ask, what is public good? One of the examples is, let's say, rule of law is a public good. Welfare services are public goods that the state provides. And how do we use AI when doing all of this? And what should be not just the limits, but the framework within which to think about this. And then this is one of my main argument during the course of this presentation is we need to ground AI use in constitutional and human rights principles. How to do that is really something that I leave all the researchers to figure out. But what I'm trying to say is that if you're beginning to solve a problem or beginning to identify an opportunity, it is important to acknowledge that there exists one. My presentation is really about acknowledging that and saying that, well, if there is a problem or an opportunity, how do we approach it? I'm talking about principles of approaching it, rather than saying that you need to do X, Y, Z, a full set of detailed rules. I don't have the current expertise to think about it, but I do have some experience of working in domains where the impact of AI is driving changes. Again, law does not have to chase technology. Like by law, I mean the normative principles of law, human rights, constitutionalism, separation of powers, dignity of the individual. Yeah. What it has to do, it has to ground it in principles that, again, as I said, that affirm the dignity of individuals and continues to safeguard our humanity. Something that Dr. Devarabli talked about in his presentation was also interesting, that human creativity has to be safeguarded, and he talked about a balance, which was for me, very insightful. Now, based on those opening thoughts, these are the ideas that have been something in the making in my mind, and also just reading things and looking at what is happening around. The first principle I want to talk about, and in my presentation now, I'll be talking about some principles, 4, 5 of them, is the principle of constitutional continuity, right? AI or any other technology cannot bypass constitutional safeguards, whether it is in the public domain, which is again very important, but also even private domain. And some of the examples in which this risk is clearly there is welfare decisions. Now, I'll just give you an example now. Think about you going to the Ministry of Education's website, not education's. Let's see the Ministry of Tribal Affairs. As part of its work, the Ministry of Tribal Affairs also has some welfare responsibilities, right? And then you have an AI chatbot that starts talking to you over the website, and then it has a bunch of questions. I don't know if you know how AI chatbots work. They give you a set of themes, you say yes or no, and then they say, oh, I can't help you, or I can help you, right? Those are the kind of things that I think has immense risks. Like, I think it is inevitable that AI will become part of some of the welfare decisions. But whether that will impact access to welfare for many people who are not, again, there's a digital divide in the country. There are welfare decisions that impact the most vulnerable people. So that's again, from a constitutional continuity lens, access to welfare is important, and I think one has to be wary of that risk. Again, there are questions of surveillance, questions of free speech. I will be discussing that in greater detail. But surveillance, again, like state using any AI mechanism to enforce surveillance, that is challenging. That's again infringing on rights of the individual. AI should not be in a position, AI for that matter, any technology should not be in a position to create exceptions to fundamental rights. Because if you say that because this technology is so interesting, so efficient, that now we could, let's say, do away with that little right to privacy that people have because of the efficiency part of it, that is that's risky, because that is diluting constitutional safeguards that exist. Constitutional safeguards exist to grant individuals, not just to grant, but to recognize the rights of individuals. And that recognition has to be maintained. Now, the idea of a constitution as a living document, we live in, in law schools, we study our constitution is a living document. What I understand by it is to help the principles evolve according to dynamic times, but not to change those principles. For example, the right to life is a constitutional principle. And over the years, we have seen so many things that have been added into the right to life, but we haven't seen the right to life being compromised. So I think that's what I understand from being a living document. Second is the principle of human rights by design and not by retrofit. This again, so human rights are pretty much enshrined in the Constitution, but there are human rights in general, the principles of human rights that must be embedded in both AI systems and also governance processes using AI. So it cannot be an afterthought in the sense that, oh, we realize that so and so right is violated because of so and so platform's use of someone's data. No, that's problematic, because then you don't embed AI and the human rights into the design of AI and how those platforms operate. So ethical frameworks that safeguard fundamental rights, privacy, informational self-determination should become part of all the platforms that we have right now that are engaging with AI. The other part is governance using AI. Now, this is where the states decides that, we're going to use AI for, as I talked about, welfare decisions. It needs to have an active assessment of what its impacts on rights is going to be, human rights of people who are, again, as I said, vulnerable, marginalized. And to any degree, it doesn't have to be just those people, but anyone who is interfacing with the state for public good. Right, if rights enter after harm, like, if you have that moment, oops, we didn't think that this would happen, or we didn't think that someone would be devoid of welfare because of the way we put up the system, governance has failed. So the responsibility of governance is to ensure that human rights are embedded by virtue. And then it's not just the human rights such as the substantive human rights, but also rights relating to processes, right to participate in decision making, right to dispute redressal. Again, that's part of our the judicial scope and other areas of work where dispute redressal is important. And this is again, this is an addition from my previous presentation. I was thinking about it, the principle of meaningful privacy. Now, privacy is not just data protection. It is protection, in my opinion. And again, this is, you could argue many things, but it is also protection from monopolistic and excessive power. Like, for example, I'm assuming all of you have like Facebook, Instagram, and those social media accounts, and those accounts come up with they have a contract embedded to it. So when you have a social media profile in Facebook, you have a contract which has certain clauses that talk about data use and privacy breach and XYZ and all of that. Now, in many of the social media platforms now, what we're experiencing is use of AI. So there is implied use of AI as part of that contract, and there's behavioral tracking, facial recognition, all of that's really there. Now, consent without alternatives is not consent but coercion. So if the world around us is so deeply rooted in social media that not having a profile is risking opportunities in life, then you have to consent to it. But do you have an alternative? That's a big question. And what is meaningful privacy is a question that will evolve. However, the principle remains that it needs to be adhering to an individual's or group or community's right to privacy. How the court looks into it, how ethical frameworks look into it, but it has to be meaningful. It is just not data protection. And this is I don't know, I'm just going to go a little on a lighter part. If you watch the movie Jab We Met, there is a dialogue there where the station master is talking to Kareena Kapoor, and the station master says, and I'm going to say it in Hindi, it says, "Zindagi rail ki patri ki tarah hoti hai, ek inch ka bend aur milo ki duri," right? And this is where I always make sure to anchor myself when it comes to AI, is that if you make one exception to AI that directly impedes on fundamental rights, that exception goes a long way. वो एक इंच का bend वो मीलों की दूरी तक जाएगा, right? So that is where I talk about principle of proportionality in the use of AI by the state. Now again, the state has not actually. I'm not sure about litigations that directly question the constitutional validity of the use of AI in governance and governance across the executive, the judicial, but I think one way of approaching this is like, again, with the Supreme Court coming up with doctrines, one way of approaching this is to say that governance must be the use of AI by the state must be, number one, justified. It must be necessary and reasonable, right? Just because it can be used, it doesn't mean it should be used. There is the element of humanity that has to be embedded into some of the systems, especially when it relates to welfare, because then you're really risking people's lives. Again, as I said, surveillance systems, risk prediction tools, facial recognition, but these are like really the more bigger monsters that people talk about. There are like smaller monsters that impact people in big ways. And one of them, as I said, was talking about how when AI becomes the interface with the government, what happens to that? And I'll talk about some of the questions of algorithmic bias that I'll talk about later. But we need a legal principle. And again, I encourage some of you lawyers, go to the High Court, Supreme Courts, and question, or not question, but like get some constitutional validity on what it means, and how does the court will approach not just the use of AI by the processes within the court, but also by the state in general. And I think the court has to come up with some directive. And those directives are not to hinder innovation. Again, going back to what Dr. Devarubli was talking about, we don't need to hinder innovation, but we really need to safeguard something. So you're approaching this from a question of safeguarding rather than hindering. And I think that's important because anyway, so then efficiency is not a justification for intrusion. So, oh, we're so productive to, with direct benefits transfer could be so easy if we hire AI models, super efficient. Everyone gets it the next day. But the problem is you're really risking something there. So intrusion is, yeah, it's a real risk. This is the principle of freedom in algorithmic spaces. And I think when we talk about free speech, we think it's the right. So freedom of speech, it goes beyond free speech. It's not just your ability to say something, but it also includes ability to access spaces that amplify free speech, right? So AI systems, when you go to ChatGPT, you write something down, you type something down, it is curating something based on whatever information it has, based on whatever keywords you have put into, whatever algorithm it follows, and it amplifies some speech and does not amplify the other, right? And how that works is really very, very interesting, technical talk. But private AI platforms now are shaping public discourse. There have been instances of, and that shaping of public discourse has also happened through courts where lawyers use ChatGPT to argue a constitutional matter, and this is shaping public discourse in one of the many ways. Now, an opportunity and a challenge now, which is, I think, is to think about how to democratize AI algorithms through being vigilant on the algorithm bias. Now, this is a process. You will not wake up one day and say, well, today AI is free of algorithm bias. Okay, so we are all equal and there's no work to be done. It's really about constant monitoring, evaluation of technology in a way that we democratize that technology. Again, this is another, from a principle perspective, freedom in algorithmic spaces, I think, is going to be important. But with that, what I would like to say, and this is the point that I've made before, I have, I guess, another 3 minutes, is I don't think that the role of law is to chase technology. As I said this before in another presentation, I think law has to be deeper than technology. It doesn't have to be faster. So our constitutional safeguards are quite deep, and our constitutional history is quite deep. That is why over the course of the years, we have evolved at least that depth to accommodate ideas that were not part of like fundamental rights. And I think with artificial intelligence, we have to do the same. But what we have to be mindful about, not just we, but like us in general, when it, when we use AI, is think about what is ethical. I think people do have a reasonable sense of what ethics is, right? If you create an image on AI and that infringes, again, going back to what the previous presentation was on intellectual property, you do understand that there is an ethical dilemma there to do that. But we go ahead and do that because efficient, productive. And that, I think, is going to be the bigger challenge for us as individuals. And I'm getting a little philosophical here with my last part of the presentation. But I think from a moral perspective, individuals like us, people who are using AI in varying capacity, have to ask that question on ethics. And yeah, I think that's how I'm approaching this in my own work when it comes to small scale fisheries and food systems and thinking about certifications and all of that. How do we embrace that sense of morality within our own use of AI? And that leads to, again, the question of education. As researchers, how are we using AI? What is its impact on plagiarism? How is that impacting knowledge we produce? But also, most importantly, how is it impacting our ability to think? There have been a couple of studies in a medical journal, Lancet, which talks about that the use of AI in individuals, especially for like very crude daily tasks, is actually impacting their ability to think. So there is a direct neurological impact that is making it difficult for people to even frame two sentences without using AI. If some of you have experienced that, it is really a degrading of our mental capacities, and that means that we are losing our sense of humanity. To make mistakes, to make even grammatical mistakes, is being human, and we have to really embrace that with an openness to learn rather than fix it with AI. Yes, thank you for, I think I have finished my 20 minutes, and thank you for the opportunity. And yeah, I'm open to any questions or concerns. Very happy to take that up.
Thank you, Anna sir. Thank you so much for joining.
On behalf of everyone present here, I sincerely thank you for your insightful session on AI in governance and human rights. Your thoughts on meaningful privacy, constitutional principles, and balancing innovation with justice were truly enlightening. You have given us a deeper understanding of how AI must be guided by human rights and legal frameworks. We are truly grateful for your time and knowledge. Thank you, sir.
Thank you very much. I appreciate the time. And yeah, if we have no, I'm assuming that I can stay back later for other sessions. Is that okay? Just to listen?
Sure, sir.
Thank you. Appreciate that. Thanks, Dr. Madhura. Thank you.
Now it's my privilege to introduce Dr. Atmaram F. Shelke, sir, a distinguished academician and researcher. Sir is a professor at Symbiosis Law School, Pune, and gold medalist in LLM. He holds a PhD in intellectual property rights, violation in cyberspace, and specialization in IPR constitutional law, administrative law, and criminal law. With over 14 years of teaching experience and numerous publications, he has made a significant contribution to legal research and academia. I now invite Dr. Atmaram F. Shelke, sir, to kindly address the gathering.
Hello, am I audible?
Yes, sir.
You are able to see the screen also?
Yes, sir.
Okay, thank you. Today we are going to discuss about what is legal framework, and what are the emerging issues with respect to cyber security, considering AI or upcoming AI. Both are considered. In first part, we'll have introduction and then general laws applicable to AI and things related to AI. And in second part, we'll discuss about issues and challenges because of AI. Some are legal issues, some are technical issues also. Both are covered in the presentation. So at the outset, we have to understand that AI is increasing like anything. It is rapidly increasing. In every sector, AI is the buzzword. You may go to the banking sector, any industry you'll choose, education you'll choose, everywhere AI has been discussed. Why it is discussed? Because people thought it will do a lot of work. And there is increasing threat at the same time. Because it can do positive work, it can do negative work also. It is human being who will decide what work needs to be done, at least at present. Because interaction between two AI, known as AI agenting, is not happening or happening in exceptional situation only. However, technology is growing every day. Changes in AI system is happening every day. Experiment in the technology is going on every day. New tools are coming, new websites are coming, new charts are coming, like ChatGPT, etc. But law is not changed with that speed. And therefore, sometimes even regulations are changed. Like CERT has issued some of the regulation, Central Emergency Response Team. So that is easy to do. But if you want to get it changed through a code, it will take time. Or through legislative authority, it may take time. So law always struggle to keep pace with the changing technology. So what is needed right now? We need a regulatory system which will provide emergency response at the same time and which will give the scope for the group, scope for the experiment, scope for the technology at the same time. Now, these are the famous area on this positively or negative, the AI is working. Like AI can be work in the threat detection. It can be used by the police officers also or by the executive to find out what are the possible threats, what threats are going on. It has been used right now for automated response system. If you call to some of the organization, including banking sector, AI will respond to your question. And even your typing, AI will give the response. On lot of websites, including educational website, etc., for admission purpose, etc., you will see the automated AI response will be given to the person. If person is not happy, person can call and inquiry can be done. So here sometimes false information is provided or allocation with respect to AI and information. Fabricated information can be created and provided. We'll go to that. It is also used by the police and otherwise for the predictive analysis in order to find out what will happen tomorrow, in order to find out how this person will react, etc. And at the same time, attackers, criminals are using AI like anything. Now, if you see the key areas wherein AI can be used and it has been used right. One is AI-powered cyber attack or warfare. There are a lot of cyber attacks. We'll take one or two examples later on wherein AI is. So AI can work like anything. If you want to create a malware, human being will take time. They have to spend time. They have to do coding, and they have to find out that how it will not be detected, etc., etc. However, if this work is given to AI, in a minute, 100 and 1,000 of malwares will be created, and it can be circulated. Same with the deep fake videos or misinformation. If you want to create it manually, it will take hours together to create it. However, AI, even ChatGPT, etc., or Rabbit AI, or Scientific AI, or any AI which is available right now, can create it in a second or a minute. So thousands of deepfake, thousands of misinformation, disinformation can be created. What you should know the prompt engineering, how to give prompt to the AI. That much knowledge is required with the person who is getting it created. So that is second area wherein AI is used right now. And in a lot of situations, deepfake are created, misinformation is created with help of AI. Third is data breach, including our Aadhaar card breach, which was the biggest scam in the entire world. There was possibility of use of AI. In case of privacy violation, like deepfake we have discussed little bit, we are going to have 2 examples of deepfake which are related to monetary consideration. We'll go to that. But even for face recognition, whenever you will go under any camera or particular camera, your face can be recognized with help of AI, which will violate Article 21 or right of privacy. Or monitoring can happen. More particularly with help of IoT, Internet of the Things. So a lot of things are connected. So my the watch, which is a digital watch, my mobile, they can take data from the internet sources like computer, etc., and that can be put up together by AI. It is known as Internet of Things. Lot of things can be connected with each other. Then they can check what are the digital footprint and how it is mapping. Whenever I am visiting website, they can find out how many websites are visited, which kind of websites are visited, what things are being brought by the person. And based on that, targeted advertisements are happening. So if you search for the any other like mobile, etc., you will get advertisement of mobile. Sometimes you're just discussing about loan at home and you'll get the advertisement with respect to loan. It is known as spoofing, and right now it is done with help of AI-driven mechanism. Malicious prompt injection can also happen. So malicious content can be created, more particularly with respect to political leader, etc. So that is point number 4. So AI has been utilized for doing this. 1 or 2 examples later on we'll discuss. And there can be autonomous hacking tool created, and general order will be given that you hack all the machines, etc., related to this organization. So it will start hacking, or it will find out how to hack, etc., or it will change what is the security provided. Now, one of the futuristic and very big threat is AI agenting, which is not yet utilized by the people. What happens in AI agentic? Point number 6. There will be 2 AI mechanisms. Right now it is tested, experimented, and successfully also it is done by some of the organization. So there will be multiple AI and they will interact with each other. They will find out generate things. For example, you are having company, which is positive example. There can be negative examples also in future. If you are having company and your target is to achieve certain economical benefit. So yeah, a lot of AI may be there. One will deal with survey, one will deal with the visit of the people, one will deal with the product and comment made on the product of the company. Another will deal with the services of the company. They will interact to each other and they will take the decision, cumulative decision. And there is no manual interference in this AI agenting. So they will take decision by so much. That is happening right. In future, it will be increased like anything. So there is generic prompt given to the mechanism that you create 5,000, 5 lakh. These are this kind of viruses in India, and that shall be put up in different sector. Like it can be put up in the educational sector. It can be there in the banking sector. Yeah, the viruses can be put up in the hospital sector. So all these things can happen. And there will be no manual intervention. And that may be in India or outside of India, and it may be difficult to find out who is doing this. So that in the future it will increase like anything. Manual intervention, one-time intervention is required, but everyday intervention is not required. It is not like that you are doing it, somebody is doing it, and again that fellow has to do or plan for the theft, etc. That is not required in case of AI agents or AI agentic systems. Another problem, point number 7, hallucination, creating false information. Even for the student of law, false cases are created by AI, including ChatGPT. So a lot of people, lawyers are working with AI. They will give prompt and they will expect some of the judgment or argument with respect to, or prayer with respect to any matter to be submitted to the court. There, sections are required. Interpretation of section is required. Cases are required. Citations are required. Precedents are required. So AI is creating new precedent which is not exist anywhere. In India also it was created. In America also it was created. And lawyer may not go back and find out whether these cases exist or not. So whatever is expected will be created. It will say create a positive argument supporting my client. Fact will be written and positive argument you are expecting. In that it is creating positive models. It is creating new case, false case, fabricated case with citation. And lot of lawyers have even submitted that case before the court of law. Cited cases of this kind before the court of law. False citations were created. So we have I have put up one example, that is Omkar asset case. But there are a lot of cases where this kind of false cases, fabricated cases, are not even detected by the court. So this is a big challenge, not only for this, for the science also. So it will create something science or scientific theory with name of somebody else, and that will be put up. So tomorrow you are searching something, you'll get a paper, you'll get information on the Google also, which is not exist at all, which is not there at all, which is completely fabricated, which is completely new creation of AI, which is not there, So it is not only wrong information, it is creating knowledge, which is wrong knowledge. So that is happening before the court of law also. So warning in this case was given by the court to the lawyer to cross-check every case everywhere. So that is the future of AI. Now I will see the example of deepfake. Previously we were discussing. So a lot of videos are created and it is difficult to find out whether it is original video or created video. One of the recent example is Bombay Stock Exchange CEO statement. There was video created, and in that video, tips were given for the investor. And based on that, a lot of investor invested the money. So it is related to money. They are going to invest in the company, corporation, etc. And that will hike the price of the shares, etc. So scammer has taken voice from the old videos, and then everything old video was taken, photos, etc. were taken, and that was put up in the AI, and AI created new video making statement that you buy this and this. There is exclusive tip given with respect to that. People, purchase lot of share based on that. Later on, Bombay Stock Exchange flagged that video, stating this is fabricated video and this shall not be used by the people while making any decision. So this is generic, but for creating panic also, this kind of video can be created. And for general people like us, it's difficult to find out whether it is original video or whether it is deep video or not. In our this one area of the publicity, there was case registered before the police station, and that fellow said that he got the call from a friend at 9 o'clock in the night, and he said there is emergency, his phone is not working, and therefore he has called from some public booth, etc. And he urgently need money on this and this account. Then he asked why on that account. So that friend said, no, there is medical emergency, his phone is not working, it is discharged, and this money is required urgently, there is accident or something. Based on that, that fellow forwarded the money, 50,000 something was forwarded. Next day he inquired, he said, no, I have not called except. But while complaining, that fellow said, the voice was same, even he has done video call, in the video call person had seen, and everything was there. So it was creation of the fake video and even fake voice. So what that mechanism has done, AI mechanism, it has taken a lot of word from the previous speeches given by the person. So a lot of speeches and everything is even updated on the YouTube and other channels. So it will take words from that or lines from that if it is relevant. So we have to give the command that this shall be statement made by this person in his own voice. Some phone call, nobody will understand whether the person is speaking or it is created with help of AI, and money was transferred based on that because it was exact voice of the friend, and therefore money was transferred. Another example, recent example, you will see the statement made by the Finance Commission in India, that is Nirmala Sitharaman. So she has made the statement with respect to some of the financial initiative, which was scam, which was fake video, and it was difficult to find out. And after that, it will say 2026 amendment to some of the laws we are going to discuss. And then after that, there was something known as path check unit under case or with some intention for the purpose of monetary gain and monetary loss in the context of Bharti Nyaya Sanhita or misappropriation of property. And these kind of videos are going on. Some are detected, some are not detected. So that is state right now. And that will increase because of agenting AI when two AI will interact. Right now, what is happening? We have to give the command, and that command is accepted by AI system, and something is created. So prompt shall be given. Prompt engineering shall be done for that purpose. In future, that is not required. That mechanism, machines, AI will interact with each other, and some target will be given. In order to achieve that target, something can be done, good or bad, because no ethic can be easily taught to AI. So if I am giving the command in general that I expect 2 crore rupees investment in my company this year, and I expect that this and this income of the company shall be increased by this and this code. It shall be doubled in a year. Now you're having 5 mechanisms doing survey. One is analyzing the market data. Another is analyzing other product and your product and tracking of the product. And consumers complain what AI is managed. All 3-4 will discuss and they will give the judgment. They will create video, which may be false fabricated video also. Decision is taken by AI agent. It is not manual interfere every time. So that is the future thing which is going to increase. It is going on, but it will increase like anything in the future. Now, what are the laws exist right now? IT law is there, 2000, and a lot of IT rules are there. 2011, as amended in 2006 also. In between, there was Digital Personal Data Protection Act, 2023. Some provision we are going to discuss in brief. And there is a Bharti Nyaya Sanhita. Previously, it was Indian Penal Code. That is also applicable. And there is a CERT, which is one mechanism, Central Emergency Response Team, which has given some guidelines, more particularly for the purpose of deepfake, etc. These are the traditional offenses which can be attracted. And there are additional offenses which are stated later on. But it is unauthorized access to the computer system, computer mechanism, or computer network can happen. 66 deal with computer related offenses. So putting virus and a lot of things will come. In the context of fake video, even identity theft will come in picture. Because you have to, take something. And there are injection issues, order issued by the court. We'll go to that. Cheating by impersonation. Even 66E also will come in picture. And breach privacy also will come in picture sometime. And breach of confidentiality. Confidential material will be there. Now, in recent amendment in 2026, Legislative Authority has put up something known as synthetically generated information, SGI, which is related to your deep fake video. Strict regulations are put up and timeline for taking it away, taking the information away is also reduced. Previously, there is objection taken or there are direction from the police officer, etc. Within 36 hour matter was taken away. And the service provider are protected under Section 79 of the IT Act. So there is protection given to them. We follow takedown approach. What is the takedown approach? If there is information with respect to anything which is objectionable on internet, that service provider like Facebook, etc., they have to take it down, they have to disconnect it within 36 hours. That time with respect to synthetically generated information is reduced to 2 to 3 hours now. Otherwise, in 30 hours or 36 hours, there will be a lot of damage. It will be circulated like anything. There is provision for mandatory labeling of AI-generated material. If you want to create it, even if it is positive material, even if it is good material, it shall be labeled as AI-generated material. So, person who is watching or reading will understand that this has been created with help of AI. This may be right, this may be wrong also. So that much precaution will be taken as per the new rule. Then reasonable technical measure is old rule in order to get protection. under Section 79 of IT Act, that is safe harbor to all platform, all social media. And then they have to take due diligence. That is the requirement of law. Then we have Bharti Sahita previously we have discussed. It may lead to defamation, sometimes deep fake video, if it is negative deep fake video under 356, and it may cause harm or alarm to the public in large or threaten to somebody under that which covered under 351 Bharti Sahita. It may be related to 77 B and S Bharti Sahita. That is, it criminalization unauthorized recording or sharing anything which is related to right of privacy. And even in case of deep fake video, pornographical video, which is related to 77, can be applied. Then we have previously discussed 66C to D, and even E can be covered. Identity theft, cheating, and by cheating by personation, etc. DPDP we have discussed previously. So under this, there are High Courts and Supreme Court judgment wherein dynamic injection can be passed. That has been done in a lot of previous cases, particularly in case of celebrities like Anil Kapoor, Pilsi, Akshay Khanna, Sunil Shetty, their voice and their image and their likeness, dislikeness, their attitude in that sense cannot be utilized by the people. So their court has issued dynamic injection. Normally, injection is issued when things are there already in order to stop the person from doing something or circulating it. Dynamic injection is issued for stopping similar thing in the future. Like one of the words used by Anil Kapoor is very famous, like jackass. Now that jackass word cannot be used by anybody right now and in future also. So this is established or treated as personal property by the High Court and Supreme Court. And unauthorized commercial or non-commercial use like defamation, etc., according to court will lead to violation of right of privacy, violation of dignity sometimes, and leading to defamation and violation of Article 21 of the Constitution. If it happens with somebody, what are the this one available? You can go for complaint. You can ask the platform or social media people to remove it. It will go to any platform. There is complaint box. So you may request by giving details, it can be removed also. And ultimately, complaint will happen under IC Act, under DPDP Act, under Bharti Sahita. And if you want to go for additional remedy, matter under 226 can be filed. So these are the basic information. Now, what are the legal challenges? If you have any question in between, kindly feel free to ask. Legal challenges, you will see, lot of things are created outside of India. Lot of data is also available outside of India. With help of cloud computing, data is kept over there. Like you will say the banking data, it is kept at 3-4 places. And whenever you are making change, automatically at every place, data will be changed. That is mechanism known as cloud computing. So lot of Indian companies, corporation data is kept in America. It is kept in Bangalore also, some data is there, and it is kept in EU. So from EU, somebody is downloading data. In EU or outside of EU, but not in India. We don't have even jurisdiction under legislation. So, and a lot of things are happening. In Pune, recently there was Cosmos case. Money siphoned off, taken away in 11 countries at the same time. So they are having mechanism, culprits are having mechanism that doing outside of India also, but our laws are not coping with that. So our laws like IT Act, which is Major Act, and second criminal law is Bharti Sahita. So under IT Act 2000, we have section 75, which deals with point number 1, that is extraterritorial offenses. It simply says, clause number 2 of 75, that the IT Act is applicable when computer mechanism, computer system is located in India. What is requirement? It shall be located in India. But for cloud, data is located in America. Your computer is located in America. Your computer system is located in America. Your internet, that is computer network, under 2K it is defined as computer resources also. PyCat is located in America. Everything is in America. It is downloaded, offense is done, it is circulated in America. And access may be barred in India. Because geographical access can be decided for the purpose of websites, etc. So if you see our website, which is www.something.in in the end. That in suggests it is India. The .uk is also there. .usa is also there. So that is country-specific website, or it is created in particular country. They may bar jurisdiction in some of the country. So .in is barred, for example. So that particular website or material will not have access in India. What it means? Requirement of 75 cannot be fulfilled in any situation. You are having video, you know it that person is accepting arithmeticals. But his lawyer will tell the court that there is 75 2 clause says for the extraterritorial offenses, computer system, computer mechanism, computer network shall be located in India. So when this fellow has done the offense, nothing was located in India. And therefore, it cannot be considered under Indian law. There is no jurisdiction in India. Whereas if you see the European approach, it is very simple. Like France legislation, if you remember, similar to the ITAR, it simply says whenever interest of the France citizen is hampered or their rights are infringed, their IT law is applicable. Whether it is from India or outside of India, it is on moon, it is on high sea or somewhere else. Their rights are violated, they are responsible. Culprit, irrespective of nationality of culprit, is responsible under European law. Whereas we have created 3 lines, clause 1, clause 2, clause 3, which is faulty legislation, wherein actual remedy is not provided. Then we have second law known as Bharatiya Nyaya Sanhita. Previously it was IPC. Section 4 was applicable to computer-related offenses, which was amended in 2009. Right now, Section 5 is applied, which is related to extraterritorial offenses with respect to computer resources. So it again says, computer or computer resources which are defined under Section 2K shall be located in India. So what is that computer resources? Everything shall be located. So suppose I take my computer to Europe, that's a laptop, and somebody takes everything from my laptop, and I have to pass. In that situation, if I'll come back, there is no jurisdiction under ITAC, there is no jurisdiction under IPC. So this is the big problem, because a lot of international offenses are happening. Unfortunately, our court do not have jurisdiction to deal with the matter because of faulty legislation. Then point number 2, we follow something known as take down approach. If there is something on internet, there is limited liability of the service provider. What is that limited? It is known as safe harbor also, safe harbor principle. They are being secure, harbor is provided to them. What is their duty? They have to take reasonable care and caution. Beyond that, even they are able to see something wrong is going on, they are not bound to stop it. They are not bound to search whether some wrong videos are there, deepfake videos are there, or something is there. So it is known as takedown approach. Time was reduced from, in case of fake news, etc., from 36 hours to 2 to 3 hours. That is one positive thing. But there is no principle followed, which is known as take care principle, which is followed in America. In EU, it is followed. So service provider has their own mechanism, and they will search continuously in order to find out whether there is something wrong on their website or in mechanism, which is take care approach. So we need to follow take care approach. Then there is possibility of mass creation with help of agentic AI or mass offenses with help of agentic AI. So on that also we have to deal, and more emergency response team need to be there. One is there at central level, which is not enough. There shall be response team in every state and every district. That kind of offenses are in place. Then there is threat with respect to cyber warfare. What our neighboring country like China has done, they are having cyber military, doing their night research on the military or how to deal with cyber warfare. So it is not actual attack with help of weapon, etc. They will put some virus and country's economy will go down or mechanism will go down. Like healthcare mechanism, banking mechanism will go down. So for that purpose, you don't require a bullet, you don't require aircraft, etc. They will hack everything and do something. So in order to avoid that, and in order to do that against another country, they have established something known as cyber military unit. America has it, China has it. India is not even thinking about having cyber warfare unit or cyber military unit. Then there is a lack of AI-specific legislation. We are having provision here and there, or existing laws are applied. But if we think about EU and other countries, they are having AI Act, specific legislation dealing with AI with respect to specific subject or in general. So there is need to have AI-specific special legislation, sui generis legislation, because this is very different subject matter. Liability question in lot of situation will come in picture. Because what happens, coding is done by one company or person. It is tested by another company and person. And prompt are given by third person. And then if it is agentic AI, it will be given by machines only. And then in that situation right now, jurisprudentially, it is not clear who is responsible or who shall be responsible. Then biases are also created with help of algorithm, intentionally or unintentionally. And then there is question of transparency and accountability. It is known as, last point, it is known as a black box approach. In black box approach, what happens? We don't know what is going on inside of the mechanism and how to deal with that. So will not understand, doctor will not understand how this mechanism is taking the decision. Lawyer will not understand how arguments are made. So it is known as black box approach. Inside what is happening, nobody knows. So there is a need to have transparency and accountability. That is not there, or there is no legislation with respect to that. In Europe, they have category of AI offenses. First level, second level, third level, and based on impact also, different category is done. And different AI also, AI dealing with the critical infrastructure, AI dealing with health, different offenses are created. So similar approach need to be followed in India. So like if you see the globally, previously we have discussed EU AI Act is there. In USA also a lot of things are there. And there is need to have international cooperation, which is not followed, So what is the need of our? We need strong AI regulation. I know there are a few changes done in 2026, which is not enough. We need to have ethical AI framework wherein the principle of human in loop, person in loop need to be followed, which is not mandated right now. There is need to have capacity building, people who are dealing with the cyber crime and cyber law, including lawyers. Lawyers are also not understanding a lot of things, more particularly with respect to digital offenses. So a lot of people are not understanding why mirroring is done, how mirroring is done, how hash value is drawn, how hash value is tested, whether it is matching or not. So you will not understand what is the authenticity of that evidence. Definitely global cooperation we have discussed. The government of India sent more than 200 letters. Letter of request, it is known as. Letter of interrogatory, it is known as. What is that? It is request to do investigation in another country. Central government has power. Out of 200, there is no single response from friendly country also to do investigation in their country with respect to offense done in India. So for that, for jurisdiction, for extradition, lot of global cooperation is required. Labeling, there is a provision of labeling.
Sir, your mic has been muted.
Sir, please unmute.
Hello, am I audible?
Yes, sir.
Yes, sir. Yes, sir.
Okay, so this was from my side. If you have any specific question, kindly feel free to ask. Okay, I hope there is no question. Thank you. Thank you, sir and ma'am, for calling me, and thank you everybody for listening me here.
Thank you so much, sir.
On behalf of everyone present here, I extend my heartfelt thanks for engaging an insightful session. Your perspective on growing role of AI and the emerging cybersecurity challenges was truly a provoking scene. You highlighted very important concerns and made us more aware of the risks and responsibility in today's technological driven world. We are grateful for your valuable time and for sharing your expertise with us. Thank you, sir, so much.
Have a nice day.
Now, it is my proud privilege to deliver the vote of thanks for today's international conference organized by Hindi Vidya Prachar Samiti's College of Law. First and foremost, I would like to express my heartfelt gratitude to all our esteemed speakers and distinguished guests, that is, Advocate Punit Chaturvedi Sir, Ms. Kriti Srivastav Ma'am, Mr. Tim Fernandez Sir, Dr. Monica Gusain Ma'am, Dr. Marcus Romano Sir, Mr. Gururaj Devarli Sir, Mr. Muhammad Anas Khan Sir, Dr. Atmaram F. Shelke Sir, for graciousing this occasion and sharing their valuable knowledge and insights. Your presence truly elevated the standard of this conference and inspired us all. I extend my sincere thanks to our respected President, Dr. Rajendra Singh Sir, for his visionary leadership and constant encouragement, which continues to guide the institution towards excellence. I would also like to express our deep gratitude to our Director, Dr. Usha Mukundan Ma'am, for her unwavering support, motivation, and for always encouraging academic and co-curricular growth. My sincere thanks to our dearest Principal Madam, Dr. Mrs. Madhura Kalamkar Ma'am, for her continuous guidance, dedication, and for ensuring that the success execution of the event. I would like to specially acknowledge our IQAC coordinator, Assistant Professor Saisha Gusalkar Ma'am, for her efforts in maintaining quality and excellence in all the academic initiatives. A big thank you to our event in charge, that is Dr. Amar Salve Sir, along with Assistant Professor Rituparna De Ma'am and Assistant Professor Tushar Yadav Sir, for their dedication, planning, and smooth coordination for their entire event. I would also extend my appreciation to the technical team, teaching and non-teaching staff for whose continuous support behind the scenes made the event run seamlessly. A heartfelt thank you to all the participants and the audience for their time, contribution, and an attentive and enthusiastic listeners. With this, I conclude the vote of thanks. Now I request everyone to kindly go through the chat box and fill the feedback form. Now we shall start with the technical section. Now it's my privilege to introduce Dr. Akshaya Desai Ma'am, a distinguished legal academic with over 10 years of experience in teaching and research. She currently serves as the head of the postgraduate legal studies and program chairperson of the LLM program at Kirti P. Mehta School of Law, NMIMS, Mumbai. Dr. Desai Ma'am specializes in human rights, health law, and constitutional law and has made a remarkable contribution through her research and publication in reputed journals. She is also a recipient of the Best Faculty Award 2024 for her outstanding academic excellence. We are truly honored to have such an accomplished and inspiring personality with us today. Please join me in warmly welcoming Dr. Akshaya S. Desai Ma'am. I request Ma'am to kindly address the gathering.
Thank you, ma'am. It's my privilege to be here. Thanks a lot for having me. And I'm really looking forward to listen to the participants' research and whatever little contribution I can give. I would be really happy to do that. Thank you so much.
Thank you, ma'am. This side, Dr. Amar Salve. I would like to tell all the participants there are two mode of presentation, either oral or PPT presentation you can do. I would like to call the name of the first participant who is going to present, Mr. Aman Ashish. Aman Ashish, are you present here? Ankita Bhoir Chandane. Miss Ankita Bhoir Chandane. Ankita, are you there? Ankita? Participant be there in the meeting. I am calling the name of Ankita. Ankita, are you there? You are able to hear me? If you have a technical issue, then we can go ahead with the next participant, Bansari Bhanushali. Bansari, are you there?
Yes, sir, I'm there.
Bansari, please go ahead with the presentation. I would like to tell you the time limit for it 5 to 7 minutes, minimum 5 minutes, maximum 7 minutes you can take.
Okay.
एक मिनट Bansari, you need to unmute yourself. I think from your side your mic is off.
Yeah, am I audible?
Yes, yes.
Uh, is my screen, are you able to view my screen?
Yes, you can go ahead. You have a time limit.
Okay, so myself, Bansri, today's topic for my research presentation I've taken regulating artificial intelligence in higher education in India, a critical analysis of emerging legal gaps and the need for a comprehensive regulatory framework. Like what are the main legal gaps, day by day AI, the use of artificial intelligence is growing in India, especially in higher education. So what are the drawbacks, or what are the legal gaps which are uh, that have been highlighted, and what is the need for regulating those legal gaps that I've covered in my research paper. AI in higher education, a transformative force. AI intelligence is rapidly reshaping the landscape of Indian higher education, presenting both unprecedented opportunities and significant challenges. Since I said that the AI, firstly, as per Nelson Mandela, education is the most powerful weapon which can which can which can be used to change the world. So, since education is so important, and artificial intelligence is rapidly, usage is increasing in the Indian higher education. So the main question arises whether artificial intelligence is a boon or a bane in the
higher education system. So AI in Indian education is a transformative force. The education system in India is rapidly evolving, embracing artificial intelligence to reshape how students learn and teachers instruct. AI is defined as intelligent machines capable of learning and decision making, is now revolutionizing key aspect of education, from innovative teaching methods to sophisticated student assessment and comprehensive research support. How is AI being used? It is being used by, in teaching methods, students assessment, and even it helps in supporting the research. Positive impacts of the use of artificial intelligence in higher education is it enhances the efficiency and improves the accessibility across diverse educational settings. The challenges which higher education faces while using AI is legal uncertainty and ethical concerns which requires a careful consideration. Firstly, education. Before we talk about higher education, firstly, uh, education itself is, the primary education itself is important. Like, uh, as as Article 21A states that the compulsory education is a fundamental right for children aged below 6 to 4 years. Article 45, which directs the states to provide care and education for children below 5 years. And Article 46 mandates promotion of educational and economic interest of backward class and weaker sections of the society. So, when we talk about higher education, firstly, uh, the changes, the fundamental rights which have been provided by the constitution are of the utmost important. Like, if there was no basic education was provided, then there was no point of higher education. So that's how the constitution has given utmost important to basic education, which has helped us to reach uh, at higher education level. The main problem of AI, while the main problem of AI in education, there is no legal framework which would define what is exactly AI, how we are supposed to implement AI. There is no clear regulation of AI in education, no clear guidelines. There is always a risk of misuse and uncertainty in academic governance. Privacy and data concern remain unsolved. Even though the new education policy encourages technological integration, but however, there is no specific definition of AI. Like, what are the standards, till what extent you can use, and what if it has been misused by someone? So what will be the barometer to check whether the work done by a particular student is his own original work, or how much the content is a copied work? So these were the problems which one faces due to lack of legal parameters in the higher education while using AI. Mainly the legal framework. Education, earlier it was in the earlier it was with state, but then education is now a subject of concurrent list. That is, the state and the central government both have the authority to make laws on educational matters. Major regulatory institutions are University Grant Commission, All India Council for Technical Education, National Medical Commission, Bar Council of India. These key legislations, these primary education laws, they all talk about enhancing education system better. And uh, these primary education laws are supported by IT Act 2000 and data protection DPDP Act 2023, which was basically enacted to protect the privacy of an individual. But none of these laws regulate artificial intelligence explicitly. India currently lacks a dedicated legislation governing AI in education or any other sector. There are not even a single act, which would precisely tell us what exactly AI is. There is no definition what AI is, what will be the consequences if it has been misused, and till what extent one can use AI. There is no such regulation. The research methodology which has been used in this particular presentation is the constitutional provision, statutory frameworks, judicial precedent, academic literature. A comparative and analytical approach is adopted to identify legal gaps and propose reforms. I would like to highlight the case of Justice K.S. Puthuswamy versus Union of India, where right to privacy was established as a fundamental right. Navigating the AI legal landscape, identifying and addressing the critical gaps in the legal framework concerning artificial intelligence. Firstly, since I said that there is no definition of AI, even though we have various acts for that regulates education, various institutes, but there is no definition. There is no standard definition that would define what is AI, and that creates ambiguity, hindering effects, regulation, and policy making. The second legal gap is privacy and surveillance. AI advanced capabilities in data collection and analysis pose significant challenges to exist privacy laws and raise concerns about surveillance. When a particular student or researcher uploads his own data on the AI, you have no guarantee that whatever the data which one has uploaded will be safe and will not be misused. Ownership and ambiguity. Unclear intellectual property rights surrounding AI generated content and inventions lead to dispute and sterile innovation. Since there is no law for AI, there is also an ambiguity for ownership. Say, for example, if a person has made a particular IT code, so whether that copyright for that IT code will be in the name of the person who actually generated the code, or it will be in the name of the AI, that is the company. So the ownership ambiguity is also a major legal gap. Liability issue, like determining accountability for autonomous AI system in cases of error, accident, or harm remains complex legal hurdle. While using an AI, many a times there is an error or accident or any liability which arises. Since there is no ownership, so along with that, which person will be held liable? Like the person who is actually giving the prompt to AI, or the AI company. This is also very much ambiguous. For this also there is a lot of ambiguity. And institutional framework. Since in higher education we have various institutes, but since there is lack of one law for one specific law regulating AI, so every institute has their own internal uh, policy guidelines which regulate AI. But again, that creates a biasness. There is no barometer to check if there are any violations, or whether it has been used in a proper manner. Proposed solution for AI governance. A comprehensive legislative and policy framework to address the challenges posed by artificial intelligence across education, data privacy, copyright, and national standards. AI specific chapter in education laws introduced a dedicated chapter addressing AI use, ethics, and accountability within existing education laws. We already have education laws, but there is no specific AI specific chapters like which actually defines till what extent you can use, how ethically you are supposed to use, and who will be accountable if there is any misuse of the same. Amend the Digital Personal Data Protection Act for AI governance. Digital Personal Data Protection Act, say for example, to give a better understanding what this act actually does. So in today's era, when a person wants to buy even vegetables, one can order it from finger of your tips. But earlier, people had actually you had to actually go to the market. But when one is ordering vegetables on their phone, so you are giving access to the site, you are giving your data, your name, your address, your phone details. So the question arises, will this data be safe? Will the site owner or the service provider won't misuse? So for protection of the data, this Digital Personal Data Protection Act was formed. But there is no specific provision that, for AI, that it will not misuse your data for any kind of data processing, algorithmic decision making. Clarify ownership under Copyright Act. There has to be clear legal guidelines on intellectual property rights for AI generated content and derivative works. It should specifically mention that it should specifically clarify the ownership rights. Like if any say for any picture is being made by AI, so who will be the owner? Like the person who is giving the prompt, or the company, or which person will be the owner? So that has to be clarified under the Copyright Act. Like while using AI in higher education, who will be the owner? Empower UGC for AI regulation. Strengthen the University Grants Commission mandate to regulate and oversee AI adoption in higher education institute. Today, UGC, University Grant Commission, it does promotes using technology and AI, but there is no specific regulation that UGC has to look after that AI is being how AI has been regulated. Also, there is a Vikshit Bharat Bill 2025, which has still not been passed, but its main aim is to club UGC, AICTE, that is All India Council for Technical Education, and other institutes into one single institute. So, since this bill is pending, the AI adoption of AI governance, AI regulation should also be a part of this Vikshit bill, which has been pending. Create national level AI education policy. Formulate, there has to be one, since one nation, one law has been passed. Same way, there has to be one national level AI education policy, which would standardize AI curriculum, teacher training, infrastructure across all education levels. Define standard AI usage framework. Develop a standard framework governing acceptable AI use in academic, research, and administrative contexts. Since there is no policy that governs AI, especially AI use in academics. So, say for example, one institute have internal policy which allows plagiarism, say up to 10%. and on the contrary, there is in the same university but in another department or another subject, the plagiarism, the use of AI is not acceptable, which creates a biasness due to the absence of standard AI usage framework. Conclusion: AI in education. AI is deeply embedded in education since its usage is has increased, and it seems like it has now sorry, almost become a part of academic curriculum, like how the internet has become. Legal gap. The legal gaps has to be fulfilled by the legal system. Legal system has not evolved equally. Key risk in inequality, misuse, and uncertainty. Mainly here I would like to highlight risk of inequality. Here Article 14 states Article 14 equality states equality, where this has been infringed. Like, uh, if there are two people who are giving one prompt, individual prompt to their AI, but there are high chances of them receiving different information, so that creates a biasness. There is no uniformity, and which in a way affects fundamental right of the citizen. AI is uh, misuse, and again it is uncertain, since I said that the even if we give the same prompt, the answers would be different. The path forward: regulation of AI is really necessary, it is not optional. Artificial intelligence should not replace legal clarity, it should operate within it. Thank you.
Thank you, Bansri. But I would like to announce again that you should please stick to timeline is 5 minutes minimum, maximum 7 you can take. But if you are going beyond it, so it will definitely prolong our session. So I would like to welcome Dr. Ravi Saxena, sir, and I would request Janvi kindly give the introduction.
Thank you. Thank you very much.
Thank you, sir. Now it is my privilege to introduce our esteemed guest, Dr. Ravi Saxena, sir. Dr. Sir is an associate professor at the Sharda School of Law with over 18 years of teaching and research experience in political science, international relations, and law. His area of expertise include constitutionalism, caste and identity politics, and human rights. He has authored several books and published widely in reputed journals, making significant contributions to his academy. We are truly honored to have such a distinguished personality among us today. I'm sure his words will inspire us and guide us all. On behalf of everyone, I welcome you, sir.
Thank you. Thank you very much, ma'am. Look forward to hearing the scholars here participating in the conference. Thank you.
Good afternoon, sir. We have already created 2 breakout rooms, and we will assign participants to the breakout rooms. You just have to join the breakout room. Sir will be in the one breakout room, and the ma'am, Desai ma'am, will be in another breakout room. You have already got the list on your WhatsApp group. So we'll in couple of minutes we'll start the session in 2 different breakout rooms. Okay.
Sure.
Thank you.
Sure. Thank you.
Yeah.